All right. Good morning, everyone. Let's get started. I'd like to call to order this meeting of the Texas State Board of Examiners of Professional Counselors. Today is Friday, June 6th, 2025 at 9:06 a.m. And we're meeting in person today at the George H.W. Bush Building in Austin. First thing we're going to do is our roll call of board members. And since we do have some new members, we'll take a little extra time to get to know them. My name is Stephen Hallbauer. I'm the board chair. I'm a public member, private practice attorney from Rockwall, Texas. I have two beautiful children, and I've been serving as our board chair now for coming up on 5 years. So start down here with the lovely Dr. Amuna. Hit the button. There we go.
Good morning, I'm Dr. Muna. I'm a professional board member.
Where are you from? What's your background?
Originally from Jamaica by way of Georgia, but I've been in Texas for almost 10 years. In my day-to-day life, I am a director of student wellness and counseling for Texas A&M University, Central Texas.
Thank you. Dr. Stubblefield.
Good morning. My name is Janie Stubblefield. I am an LPC and board approved supervisor, and I serve as a professional member here on the LPC board. And I am in Dallas, Texas, and have a private practice.
Thank you. Dr. Bradley.
I'm Loretta Bradley. I am a professor at Texas Tech University, and I coordinate the counselor ed program there. I grew up fairly far from here in Kentucky, but I've been in Texas for several years, and I'm a professional member.
Thank you. And let's meet one of our new members.
Good morning, everyone. And my name is Elisa Chan, and I'm very pleased and honored to be serving on this board. Yes, I'm a new board member, and I know I'll have a lot to learn. I was born in Taiwan, but as they say, I came to Texas as soon as I could. And I've been living in San Antonio, Texas with my husband and also daughter for 37 years. I actually been very involved in business. My husband and I, we own a structural and civil engineering firm. And we have a long story about how we started, but I'm happy to report that we've been in business for 33 years. And I serve on San Antonio City Council for 3 terms. I was the first Asian American immigrant to ever hold that position, learned quite a bit. And I continue to be very involved in the Asian community in San Antonio, in business, but also in politics. By the way, Chair, you may not know, I'm also a precinct chair. So I'm very happy to be here with you all. And I hope that I will make my contributions to this board. Thank you.
It is great to have you. Thanks for joining us. Thanks for giving our board a shot. And our other new public member is Corey Rose. He's joining us via Zoom. So Corey, let's hear a little bit about you.
Yeah, good morning, everyone. Corey Rose, like the chair just said, a fellow new public member. I'm from Austin, Texas. So sorry I couldn't be there this morning with you, but dealing with a bit of a house emergency today. Very excited to serve with you all. I work in economic development for the Austin region, but I'm a one-time 10-year state employee, so a little familiar with state politics. Again, looking forward to serving with you all and getting to know you and serving our state. So thank you.
Thanks, Corey. Sorry about your situation. We'll look forward to meeting you in person sometime soon. I will note that we have the excused absences of new public member Brian Eby, and we have the excused absence of Vice Chair Dr. Christopher Taylor. We do have 6 members today. That certifies our quorum, and I will hand it over to Christina for staff introductions.
Good morning. I'm Christina DeLuna. I am the board administrator for the LPC board. I've been in this role since 2016, and so I know a lot of your familiar faces. We also have Brenda Skiff, who is the executive assistant here at the end. We also have Patrick Hyde, our general counsel, and Daryl Spinks, the executive director of BHEC. And McGregor Monk, who is our IT and makes sure everything works for us to have these meetings. Thank you.
Thank you very much, Christina. Um, Item number 2 is welcome and announcements. Kind of incorporated that into our introductions. I wanted to just talk a little bit with our new members. Both of Corey and Elisa are new public members, and so I do kind of have a standard spiel regarding the role of the public members on the board. And as a public member myself, I try to follow this same directive. And the board as itself, our job is to protect the public, and that has lots of different facets. We do look out for the safety of 30 million some odd Texans and their efforts to seek effective and reliable and really great mental health treatment. But I've always kind of viewed another part of that directive is making sure that our Texas mental health professionals we give them the tools, we give them the authority, we empower them to really be the best professionals that they can be. And that's how I view our directive. If you were to take all that and kind of boil it down, public members' job is to ask questions. Say, all right, that's that joke. Explain this to me like I'm 5. A lot of times we have to say, okay, I'm not a professional member. Can you explain this a little bit more to me? Because this doesn't make sense. And so it is our job to question, to push back at times, to say, this doesn't look right. And that's what Corey and Lisa join me in doing that. It is not our job to rubber stamp everything. We are to ask questions. We're to scrutinize. We're supposed to, like I say, there are 30,000 Texas mental health or Texas LPCs, but there's 30 million regular citizens of Texas. And the public members, we're looking out for 30 million of Texas residents. So, you think you can handle it?
Yes, sir. Yes,
I have confidence in you. Okay. Board, anything else that you want to add to that? Okay. We will go ahead and move on. Item number 3 is public comment. Christina?
Awesome. We have 7 individuals here in person who will do their public comment first. And those of you that are on Zoom, if you can go ahead and raise your hand in the Zoom function so that we can get to you after the public comment of those in person. So the first one we have today is Angela Bowles. And if you can please identify yourself and what organization you're with.
Good morning, board. My name is Angela Bowles. I'm a licensed professional counselor supervisor and the Texas Counseling Association liaison to the board. TCA appreciates the opportunity to provide public comment. However, at this time, this TCA liaison does not have an official comment on this particular agenda, but is listening to the discussions today and processing the information shared. We look forward to hearing from our membership in the weeks following this meeting and hopefully hearing and gaining a better understanding in the future board lunch and learn hours. As we close out this legislative season, I hope that we can all catch our breath and remember that we are not on break because the work for the next season begins today. As always, TCA would like to thank the board for their dedicated volunteer service to our profession and those that we serve in the great state of Texas. Thank you.
Thank you. Next person we have Emmanuel Tamarez. I apologize if I said that incorrectly. Okay. Okay, thank you. Next we have is Philip Crum.
Morning, everybody. I'm Philip Crum. I'm one of those 30 million people you're responsible for. I'm Joe Citizen. I'm a co-founder of AMP as well, and I'd like to welcome to the new board members. Now, whether you realize or acknowledge it yet, I think the mental health profession in America is on systemic life support. Our family structure is broken and traditional roles have been vilified in the name of individual truth, and half of our licensees support that with an "if it feels good, it must be right for you" mindset. Our K through 12 education is under assault by cultural Marxists masquerading as teachers and school board members. Now, I understand that BHEC has no jurisdiction over school counselors, but the public doesn't know that, or do they care? And the school counselor involvement in the social grooming of kids is negatively impacting our side of the counseling profession. Our higher teaching institutions are staffed by activists, and our grad programs are producing professionals who've largely abandoned a do no harm ethos concerned only about not offending a client and affirming their self-diagnosis in the interest of subjective truth. Many counseling students are opting to change career plans, contributing to a workforce shortage, and many in the above 50 crowd are opting for early retirement or other lines of work. The healthcare disciplines are siloed and do not work well together, and in fact are often at odds with each other. Our licensee base is fractured into two groups: the old school science and evidence-based practitioners and those who practice a form of faux medical care driven by social ideologies. Public is very, very aware of this split, and they don't trust us anymore. They're also aware that the 5 prescriptions they're on aren't fixing their problems. Our legacy professional associations across all disciplines went woke a long time ago and now openly promote the social justice agendas, lobby against legislation that aims to protect our nation and its children, and do this openly on their websites and in public. That realization is driving change at the grassroots level. And while we're not yet at a public tipping point, we're very close, and this profession is nowhere near ready for it. The news is not all dire, though, as there are parallel economies in all businesses, on the academic level, and in the professions, including counseling, that are being developed right now, will replace what doesn't work and can't be fixed. Mental health care is about more than a myopic neck up, give them another pill approach. It needs to address the entire body as well as the mind and spirit as contributing factors. The public is increasingly aware of this, and I just simply don't think we're ready for the change that's coming. We believe that in 10 to 20 years, maybe less, the counseling profession and its practice will look nothing like it does today. There's a sea change coming in the world of healthcare, and counseling will be unavoidably swept up in it, largely because the American citizen is fed up with it all. So again, I'd like to welcome the new board members. I sure hope our boards are up to the challenges ahead. I sure hope we're all up to it. Thank you.
Thank you.
Thank you. Next we have is Kathleen Mills.
Good morning. I'm Kathleen Mills, licensed professional counselor supervisor, and I currently have 4 supervisees, associates. I watched the video of the last MFT meeting and was dismayed to hear the head of the board calling for action to interfere with the financial relationship between a business owner and its labor force. I don't believe that type of action is within the purview of any of our boards. Splits are determined based on business expenses and the right of the person who's putting up the capital to run a business and make a profit. Splits are not determined based on feelings, social ideology, or what the uninformed who wish to run things from their Facebook groups think. An entitled generation of grad students has made enough noise to convince people and professors that any split that doesn't meet their arbitrary idea of what's fair must be coming from a heartless, greedy supervisor. That's not the case, and I find it insulting that the MFT board even implied that. I certainly hope the LPC board doesn't follow them down that inherent, unfortunate line of thinking. Here's 3 things to consider. Maybe academia could take just 60 minutes and teach grad students how business-oriented splits are based on business expenses and not social entitlement. Manage some expectations that would really help our interview process out here. Maybe the boards could set an example by not giving credence to the idea that all supervisors are greedy opportunists. Just because a grad student with only 300 practicum hours and 80K in social school loan debt I had nothing to do with isn't taking home 70% or more of every dollar doesn't mean I'm a bad person. No business owner takes home 70% of every dollar. If an associate doesn't like the split being offered and the program that goes with it, then please vote with your feet and look elsewhere. That's how the free market works. Academia needs to better inform their grad students how the economic process works. Do associates' expenses matter more than the employer's costs? It's not my duty or obligation to pay off someone else's debt or pay out what they think I should just because someone on social media or AI has determined what's fair or not. Running a business is expensive. Student debt is out of hand. But looking to make supervisors a scapegoat is not the answer. I suggest you spend your time overhauling the 40-hour supervisor training requirement to something that more closely reflects how the real business world works. I'm calling on academia to actually teach grad students what all is involved when running a business. I would be happy to consult with you, the board, and academia if I could help you at all. Thank you so much.
Thank you.
Thank you. Next person we have is Rhonda Velders.
Good morning. How are you? My name is Rhonda Velders, and I am an LPC supervisor in the state of Texas. And I run and own my own private practice, Illuminated Pathways Family Therapy, LLC. And I'm just here to discuss a bill that is going to be in effect unless it has the passage votes that it will go immediately, but otherwise it will be done and set ready to go for September 1st. And this is called HB 3515. And this has to do with reunification. And it's the SAFE Act, I might as well just read my notes, I'm sorry. I wanted to share information regarding the HB 3515. This bill is an act relating to regulating parental reunification therapy in a suit affecting the parent-child relationship. This act shall be known as the Safe Haven Act. While I am not a reunification therapist, however, I have several of my own youth that I take care of that are forced to go through this reunification. While I am an advocate to reunifying the family, I'm not an advocate to reunifying the family in a coercion type environment where they are forced to sit in something that is still unsafe. And when it's reported unsafe, it doesn't get taken care of. So I'm really excited about this bill being put in place so that it can help protect the children. And so while, again, I still really believe the reunification, when it's done in a healthy way, and it's done in a way that it doesn't re-victimize the client or the child, I think this is an important thing because this is stuff that I have 3 clients that I take care of personally. And 2 of them are forced through a court order where the one parent now who brings the child to therapy, then I've had to testify in court to get the reunification to take place. Now that parent has been ostracized and not ever able to be involved. And so I think this bill will allow where the collaboration of the reunification therapist and the me, like for example, me, have to work together in the process of this, and it makes sure that both parents are involved in every decision making. So I'm really excited about this because as of right now, I am not being communicated with. My child feels like she's not heard, she's being re-victimized. I have 2 of them like that. And so this particular bill will help protect those children. And I just wanted to make sure that that is made known, that this is one of those bills that I find, for me, I do a lot of criminal work for children who have been sexually abused, who have been abused. And that's just kind of the things that kind of come through my office. And so I'm excited about this. And I really want to make sure that all therapists know that this is coming and that you have to get to a place where you're collaborating with the original therapist so that you can help give that information. So this is HB 3515, and it's the Safe Haven Act. And I just wanted to make it aware. That's all. Thank you.
Thank you.
Thank you. Next person we have is Diane Smedley.
Hi, is this on? Okay, here we go. All right, y'all. Okay, good morning, Chair Hallbauer, board members and staff. My name is Dr. Diane Smedley. I'm an LPC supervisor, LMFT supervisor, and a counselor educator. Additionally, I have had the distinct pleasure to serve TASIS as the LPC board liaison. TASIS, for those of you who don't know, is the division of TCA that is dedicated to strengthening counselor education and supervision. I'm grateful for the opportunity to make public comments today and thankful, of course, as always, for board member and staff's continuous hard work. So first, on behalf of President-elect Dr. Melissa Alvarado-Beal, I just greatly appreciate the board members who came and spoke at the Midwinter Conference back in February. I'd be amiss if I didn't specifically thank Dr. Stubblefield, Dr. Bradley, and Ms. DeLuna. Your openness, transparency, and vulnerability during otherwise very tense conversation is just really greatly appreciated. We appreciate your willingness to lean in and engage with membership. Specifically in today's meeting packet, there are some numerous proposed changes related to LPC associates and LPC supervisors. Many of these changes parallel pre-sunset expectations, which is a bit confusing for us. The proposed changes will impact supervisors' responsibilities and liability, adding additional burdens related to record keeping, related to documentation, so on and so forth. BHEC's own workforce data, again, I know I harp on this a lot, but it indicates that continuously rising supervisor liability is why LPCs are reluctant to supervise. Changes as those proposed have a detrimental impact on the number of available supervisors. Furthermore, some of the new language appears vague and incongruent with the actual goal of clarity, specifically, or such as, this isn't the only examples, but 681.91C and 681.93H. In fact, related to the 1H, which talked about locations, I actually did this kind of brief informal poll to supervisors and was like, hey, when it says location, what do you think that means? I couldn't get a single congruent answer from anyone. And so if we are going to enact rules like this, we need to do it in a way that doesn't continue to burden supervisors and kind of change the game. As stakeholders, we do appreciate opportunities to collaborate with the board in rule creation decisions. Collaboration allows for efficient rule creation that promotes clarity, reduces unintended consequences, and results in rules that support rather than burden the supervisor tasked with upholding them. Finally, this is where it's emotional. After 3 years of service today marks my last board meeting as the TASIS liaison to the LPC board as I step out of this role and into the president-elect position for TASIS. I'm excited to introduce to you our new TASIS liaison, Carrie Proctor, who I think is speaking after me. She'll do phenomenal work collaborating with you all and advocating for counselor education and supervision. In closing, thank you again for the opportunity to make these public comments and for your continued dedication to the citizens of Texas.
Okay, now we have Carrie Proctor.
Hello, good morning, and thank you for the opportunity to speak today. My name is Carrie Proctor, and I am an LPC supervisor and the incoming TASIS board liaison. I look forward to serving as the Texas Association for Counselor Education and Supervision liaison to this esteemed board. I've attended meetings virtually and in person and have witnessed difficult conversations as the board balances removing barriers while maintaining high standards. I respect the hours of work that staff and volunteer members dedicate to our profession and to protecting the citizens of Texas. A prime example of removing barriers is the final rule adoption under application materials 681.72 related to the removal of the expiration date on supervision training courses at both doctoral level and the 40-hour clock hour course. The standards of training courses were maintained while removing an obstacle. I personally know supervisors who had to take the course twice because of the 5-year expiration date. Many conversations have been had regarding the language changes with 681.140 under continuing education requirements, also up for final rule adoption today. The requirement for continuing education and cultural diversity or competency has been changed to distinct populations. I'd be remiss if I didn't acknowledge that language matters to our members, and the removal of the term cultural diversity raised discussion and concern. We recognize that even with the language change, we still have the autonomy of choice for CEs in this area. It will be important for counselors, educators, and supervisors to continue to carefully select and provide trainings that adequately prepare us to serve all Texans and their unique needs. Lastly, there are several changes under 681.93 supervisor requirements that appear to create increased liability and documentation responsibilities for supervisors. The supervisory record will now need to include the duration of supervision with the date, which seems duplicative. I can't talk today. Duplicative, since we're already tracking the monthly hours of supervision. Additionally, the proposed rules include maintaining a record of all locations of practice, whereas in the past, any site changes and additions were maintained by the licensing board. If an associate has more than one supervisor, would each supervisor maintain the list of all sites or only the sites that they are responsible for providing supervision? What are the consequences to the supervisor if an associate fails to provide updated information? Additional information on the rationale for the change and consideration of the impact would be helpful. There appears to be a trend towards adding responsibility and liability to supervisors, which can be a deterrent. There's a fine balance between wanting to grow the next generation of counselors and being willing to risk your own livelihood to do so. I wish to thank the LPC board and staff for your support and willingness to engage in these conversations. I look forward to working with you in the upcoming months in my TASIS liaison role. I will respectfully share input from our membership and honored our shared goal of ensuring quality of counseling services to adults, children, and families in Texas. Thank you.
Thank you. Is there anyone else in the audience who would like to provide public comment that did not sign up? Anyone else?
No one? Are y'all here just to observe a board meeting? All right. Any questions? Or-
Ms. Proctor, Ms. Proctor, I have a question. That young man sitting right back there in the corner, can you tell us what's wrong with him? I know you were his school counselor. Saved by the Bell McGraw.
All right.
Last chance for any in-person public comment. All right. Well, welcome. Are y'all students? Oh, okay. Well, welcome. Okay.
You want us to mess with them?
They're associates. Let's go to the those online.
Okay. So again, anyone who would like to provide public comment who is on the watching the meeting by Zoom, please go ahead and raise your hand. *6 if you need to unmute yourself for anything. So the first person I have is going to be Kate Walker.
Hello. All right. Can y'all hear me? Are we starting the timer? Excellent.
Yes.
All right. I'm Dr. Kate Walker, and I'm the owner of Kate Walker Training, and we offer the 40-hour trainings to become an LPC, LMFT, or social work supervisor in Texas. And by the way, we do include business education for the future and current supervisors in our programs. I'm a licensed professional counselor supervisor, a licensed marriage and family therapist supervisor, and I'm also former president of TASIS and liaison to the LPC board. Welcome, new board members, and thank you, board and staff, for all your hard work And thank you, Christina DeLuna and Robert Romig, for your willingness to speak at our free webinars that we offer to any and all mental health providers in Texas. I'm going to talk about an existing rule and 3 proposed rules. Existing Rule 681.91L, which talks about the possession, access, retention, control, maintenance, and destruction of client records, is the responsibility of the person or entity that employs or contracts with LPC associates, or in those cases where the LPC associate is self-employed, the responsibility of the LPC associate. I have a problem with this because it assigns responsibility for client records based on employment or contract status rather than allowing the terms to be defined in an employment agreement. The language suggests that an LPC associate who is contracted as a 1099 contractor and therefore self-employed under IRS guidelines cannot control the records they create. This creates confusion and restricts legitimate practice models. I urge the board to revise or remove this language and allow employment contracts to determine record responsibility. 681.91, this is a proposed rule about remediation. I have a problem with this because it treats a successfully completed remediation plan as if it were a disciplinary action that must be disclosed to all current and future supervisors. If the plan is completed, there should be no ongoing obligation to report it. A more balanced approach would be to simply note in the online profile if the remediation plan was not completed. This respects due process, reduces administrative burden, and avoids unfairly labeling associates who have addressed concerns appropriately. In a related issue, there's no easy way to verify who an associate has been supervised by, which complicates enforcement and oversight. Adding current and past supervisors to the online profile would streamline investigations, improve accountability, and make remediation related more practical and verifiable. Finally, 681.93A1D. I have a problem with this because adding the word duration is meaningless without defining what constitutes 1 hour of supervision. LMFT rules define a supervision hour as 50 minutes, which has already caused confusion among LPC supervisors, especially when tracking the required 4 hours per month. There's still no clarity on when supervision officially begins for the purpose of meeting that requirement. This rule seems like a step toward pre-sunset record keeping, and I would ask the board to clarify the purpose and intended use of this addition. As you can tell, I want to echo broader concerns raised by others in the counseling community and the one about the supervisory session. Same thing, it's just unnecessary burden on administration and staff. That was it. Thank you guys so much. And thank you for your hard work.
Thank you.
Okay, next person we have is, and I failed to just remind everyone that this time is not to discuss any cases, open complaint cases or application cases. So just wanted to throw that out there real quick. Next person we have is Gracia Cardenas.
Hi, thank you. Good morning, members of the board. Thank you for the opportunity to speak. My name is Gracia Cardenas. I am actually, like you said, I'm an applicant for the LPC associate license. My case is a little different because I'm from Mexico, so I'm trying to get the license here to be able to practice in the States. So I'm waiting. I understand that the board is determining whether I'm deficient in specific coursework. So I just wanted to comment on what should be once I get that, how would be the best way to proceed. I would like to know if I can complete the missing credits by taking standalone graduate level courses at a regionally accredited university, or if I'm required to enroll in a full new degree program. My goal is to fully comply with the board's standards while also taking the most efficient path to our licensure. I would appreciate any guidance the board can provide to help me move forward on the process. As I think I'm a little intimidated by the rest of the commenters.
Ms. Cardenas, we cannot comment about your specific case during a public meeting.
I'll reach out to you, Ms. Cardenas, and see where we're at and what we can do and what we've sent. So just after the meeting, maybe even on Monday, maybe I'll get back to you and see where we're at. But thank you. Do you have anything else besides that?
No, thank you so much for your time. I apologize, but thank you so much for your consideration. Thank you.
No problem. Thank you.
Thank you.
Okay, next person we have is Lori Hollingsworth.
Good morning. Can you hear me? I'm at a conference and there is background noise. I'm going to do my best. Good morning, Chair Haubauer, board members and staff, and welcome to the new members of the LPC board. My name is Dr. Lori Hollingsworth. I'm a licensed professional counselor and supervisor in private practice, a counselor educator, and the current president of the Texas Mental Health Counselors Association, a division of TCA and the Texas chapter of the American Mental Health Counselors Association. First, I want to express our sincere appreciation to the LPC board and staff for your ongoing service as professionals and public servants. TOMCA deeply values the opportunity to offer public comments and engage in meaningful dialogue as stakeholders regarding the rules and regulations that shape our work as professional counselors across the state. We also thank Dr. Loretta Bradley, Dr. Janie Stubblefield, and Christina DeLuna for representing the board at the 2025 TOMCA Spring Conference in Kerrville, Texas on April the 25th. Your willingness to engage directly with counselors from across Texas speaks volumes about your dedication to transparency, collaboration, and the continued advancement of our profession. TOMCA is keenly aware that the focus and the mission of the board is to protect the citizens of Texas. This will be my last time to attend the LPC board meetings as the president of TOMCA, and there's a sadness to that. I have enjoyed working with you. I'm turning it over to Dr. Brett Hendricks, who is the incoming president, and he will do very well in this position. I don't have any specific things to say about the proposed rule changes, except just to continue to offer clarity as much as you can and to eliminate any additional burdens to the supervisors. Thank you again for your time, your thoughtful considerations of our concerns, and your continued service to the citizens of the great state of Texas.
Thank you.
Thank you.
Next person we have is Lanika Graham.
Good morning, everyone. How are you guys? My name is Lanika Graham, and I'm a licensed professional counselor associate in the state of Texas, supervised by Dr. Joy Dale Snook. Thank you for the opportunity to speak today. I come before you not just as the one professional, but as the voice of countless associates across Texas who are struggling under current conditions. I had the pleasure of submitting a petition for review, and I truly appreciate the opportunity to do so. As an LP associate, we are professionals. We've earned graduate degrees, passed national exams, and even deliver essential skilled care. And yet many are paid 0 to 50 per hour for direct hour only, with no compensation for cancellations, no-shows, or documentation. Many are often working for less than 25% after taxes, while business owners take 75% or more of the revenue that we generate. Many are required to pay $200 to $600 a month out of pocket for supervision, often with minimal mentorship or accountability. Supervisors did not complete their education to make a living off of LPC associates, and we are not their clients. Supervision should not be approached primarily as another income stream, but rather the core intention should be about supporting and building up the next generation of counselors. Of course, I understand that this is also a business, but the advocacy here is for fair wages and supervision costs, not for undervaluing anyone's work. When you add basic living needs such as housing, utilities, insurance, and other expenses, the math stops making sense and starts feeling like exploitation. For many, this creates net financial loss. Average your current basic living needs with the wage of an LPC associate and tell me how much debt you'd have left over. Let's be clear, this isn't just unsustainable, it's unethical. We don't do this work for the money. We do it because we care, but passion and loving the work should not mean suffering for it. And this board has both the authority and the obligation to act. Under 503-2015 of Texas Occupations Code, the board must propose rules that ensure ethical practice. Under 503-208, it must define competent professional performance, which includes ethical supervision and provide proper oversight. While you can't set wages, you do have jurisdiction over the ethical treatment of LPC associates, supervision standards, and preventing exploitive practices under licensure. So I ask you, how is this ethical to misclassify associates as 1099 contractors when they clearly meet the IRS definition of W-2 employees? How is it ethical to charge thousands in supervision fees with little transparency, mentorship, or recourse? How is it ethical to allow contracts that strip emerging professionals of their dignity, rights, and a fair shot at success? How is it ethical to pay associates low wages and charge them for supervision, often with fees going directly back to the same business? This practice undermines fair compensation and contributes to financial hardship. This is happening not in only underfunded nonprofits, but
Mrs. Graham, Mrs. Graham, your 3 minutes are up.
Okay, I asked for more time. Other people have went over. Can I please finish?
You have about 15 more seconds. I've already let you go over by 45 seconds.
Okay, this isn't about undermining the work of anyone within the profession. It's about ensuring our system reflects fair ethics that we're trying to uphold. Outrage alone isn't
Thank you,
enough
Ms.
to
Graham.
bring change. But
Thank you.
Next person we have is Richard Stride.
Good morning, everyone. My name is Richard Stride, and I'm from Washington State. My wife and I will hopefully be moving to Texas here in the next year or so. But just wanted to comment on a couple things. I'm dealing with the state board concerning application and was a little disappointed as far as the reciprocity, but I understand that each state has their own obligations and their own way of doing things, which is certainly appropriate. I'm licensed as an LPC in Colorado and also as a licensed mental health counselor in Washington State. I'm currently the CEO of what we consider a rural mental health center. We have about 300 employees, and we do inpatient, outpatient, and substance use treatment and other sorts of treatment for individuals. But just happy to be here. Wanted to chime in and listen to what's going on with the board, and happy to continue the application process. Oh, and by the way, Christina has been fabulous. She's great. Talked to her a couple times, and she's very helpful. So thank you.
Are you?
Sorry, I can't help it.
That's correct. Christina is great.
Thank you, Mr. Stride. Next person we have is Rebecca Smith.
Good morning, Chair
morning.
and Board. Thank you for the opportunity to speak today. My name is Rebecca Smith, and I'm a licensed professional counselor and supervisor. I come before you not only as a mental health professional, but as a concerned Texan and advocate for child protection. On May 24th, the Texas House passed Senate Bill 12, the Parental Bill of Rights, championed by Senator Brandon Creighton and bolstered by Representative Steve Toth's Amendment 12, which is now law. This prohibits all school employees, including licensed professionals, contracted or employed by public or chartered schools, for participating in social transitioning of minors. This includes using names or pronouns inconsistent with a child's biological sex or affirming a gender identity without parental consent. This legislation is a major step towards restoring trust between schools and families and preventing the kind of ideological overreach that alienates children from their parents. SB 12 affirms that many of us in the field already know Parents are essential to the child's psychological well-being, and any therapeutic intervention must strengthen, not replace, that relationship. Under SB 12, it is now illegal for any school-affiliated mental health provider to assist a child with social transitioning, regardless of intent or perceived clinical benefit. Amendment 12 leaves no room for interpretation. Licensed professional counselors must comply or face grievances, investigations, and potential disciplinary action. As we await Attorney General Paxton's formal opinion on whether mental health professionals fall under the 2023 HB 14 ban on gender modification procedures, I urge the board to prepare for the inevitable. Whether it comes by opinion or by statute in the 90th legislative session, the practice of social transitioning by licensed providers, especially with minors, will be codified as unethical and unlawful. This ideology is collapsing under its own weight, and it is not evidence-based, it is not safe, and it's not sustainable. We have over 75,000 active licensees in Texas, and with 40 states that are now participating in the PSYPACT, the coming wave of grievances and litigation will be massive. This board will be flooded with complaints from parents and detransitioners in the coming years, but there is hope. Conservative mental health professionals across Texas are finding their voice. We are banding together, standing firm in truth, and raising the alarm, not out of hate, but out of love and duty to protect the vulnerable children from irreversible harm. We will not back down until the psychological and physical mutilation of children is eradicated from every corner of our state. I ask the board to take these changes seriously, to educate licensees proactively, and to be prepared to defend the core ethical duty of our profession, to do no harm. Thank you.
Peggy.
Thank you. Next person we have is Jessica Bollinger.
Hello, can you hear me?
Yes, ma'am.
Yes, I am a solo private practice clinician. I'm an LPC, NCC, and certified clinical trauma professional here in San Antonio, Texas. I was just attending because I saw it. I've never attended before, and I just had a few things that I wanted to just listen, and a lot of people have already touched on a lot of them, other than one thing I've always had a concern about. I've been in practice since 2014. The jurisprudence exam is probably the one I haven't heard anyone mention. I just wondered if anyone is considering changing that to not a no-fail test, because I feel like paying for it and I can't fail it kind of defeats the purpose of taking it, because I mean, I've taken it so many times. I just wonder why I have to pay for it if I can't fail it. Not that I will ever fail it, but I mean, it pops up the answers. It almost feels like I don't understand the relevance of it. I would like to just hear further comment on that. And maybe suggest that it be not fail, like not a guaranteed not fail test versus some, because I have seen people say they fail it also in Facebook therapist groups, and I don't even know how they fail it if the answer is you can literally pop up. So I'm confused about that. The flip side of that, the reason I was attending this is because I've been a member of the TCA, the Texas Mental Health Counseling Association, ACAC, a ton of them, SAGE, Texas SAGE, etc., as well as a ton of ACA and APA and their subdivisions. And I have not renewed my TCA membership, which expired on May 31st yet. And I thought maybe attending this would reinvigorate my motivation to rejoin the Texas Counseling Association as a member, since I have been a member for 11 years, because I haven't been getting any kind of streamlined information about the CEUs. Even I can't even contact, I don't even know the contacts to half of the subdivisions that I pay for. And it's not till after the fact I see it on the newsletter. I click the link and I'm like, oh, wow, I can go back and watch YouTube, for example, and watch, I don't know, 3 or 4 months worth of CEUs that were available, but I was never sent that information. Texas Sage, I tried to go to their website to download stuff. I always have to like send a personal email to the president or someone. And a couple of days later, I'll get a generic passcode to their website. Same with the TMHCA. Recently, I was told I couldn't
Ma'am,
obtain
your time
credit.
is up.
Okay.
Your time is up. Thank you.
I would just like updates on that and see if they're going to streamline how we can
Okay,
communicate.
okay. Thank you.
Okay, we have Kyle. I'm not even going to try and say the last name. Here you go, Kyle.
Hello, thank you for letting me speak. My name is Kyle Malazdritz, and I am an LPCA associate supervised under LPCS Ian Hammonds. For one, I want to applaud Lanika Graham for her great words, and I also want to stand by her and agree that the cost of supervision is out of this world for LPCAs, and a lot of the LPCSs are from the older generation, and the cost of living is almost double what it was back then. And we aren't asking for LPCSs to get paid less. We are just asking for fair wage and to cover the basic needs. Coming out of grad school, I wasn't really made aware of the cost of all the tests, the documents I had to send to the BHEC, which totaled hundreds of dollars. And then finding a supervisor was roughly $365 without seeing a client. And so that puts us in a hole. And that is why I agree with Lanika Graham. And I appreciate everyone hearing me out. And I hope everyone has a blessed day. And mental health matters. Thank you.
Thank you.
Thank you, Kyle. Okay, and we have Sandra Martin.
Good morning. Can you hear me?
Yes.
Yes.
Okay. I am Sandra Martin. I'm an LPC supervisor status, if you call it status. I'm a governmental liaison for Christian Counselors of Texas. We're happy to be back with you this year, and we welcome new members on the board. We look forward to hearing you speak and kind of giving us your idea of who you are and how you fit in here and why you are sitting on the board, which is a very difficult task and a very time-consuming task. I am given to understand that it's wise to hear and see before we speak. And so Christian Counselors of Texas at this moment, I'm speaking through them. And I think we want to hear essentially the new board and how it's put together and how it works together before we speak. We have much to say in a variety of subjects. But I think we need to hear this new board pretty clearly before we speak so we can shape what we say to accomplish, or at least to be carefully heard when we speak. We have had good relationship with the boards, all of the boards in BHEC. We're so grateful for that good work. And we wish you very, very good work in this year coming up. It's going to be a tough year for you, probably. So we're glad to be working with you. Look forward to hearing you, and we'll be at your next meeting. Thank you so much.
Thanks, Sandra.
We have one phone call person. Let's see. Go ahead. You can do *6 to unmute yourself.
Good morning, everyone. Can you hear me?
Yes.
Yes, ma'am.
Thank you. Good morning, and thank you for the opportunity to speak in this meeting. My name is Karen Herrera, and I am an LPC supervisor. And the reason that I was compelled to speak today is just to please understand or take in consideration that as LPC supervisors, we invest years into clinical practice, ongoing education, specialized training to be qualified to guide LPC associates in becoming LPCs, fully LPCs. Our time, knowledge, and responsibility come with value, and that value reflects in our rates or the fees that we set. If a supervisor, or my ask is, if a supervisor does not align with the LPC associate needs, especially the financial needs, then it will be my recommendation to them to look for an LPC supervisor that fits for them. Please, I ask to please do not attempt to dictate what supervisors should charge. This mindset is not only dismissive of the worth, the professional worth, and the time and the commitment to a profession, it also could contribute to burnout as an LPC supervisor and potential shortage of supervisors willing to promote this important work. I please ask to take in consideration the work that we do, the investment, the time, the money that we invest to become LPC supervisors, and by limiting or setting a set range or fees, I think it will set a price or a value to our work. Thank you. That is all.
Thank you, ma'am.
Thank you. That completes our public comment. I just also want to note for the record that we did receive 55 written public comments that were also provided to the board members.
Thank you, Christina. Yeah, building upon that, thanks to everyone who submitted the written comments. Speaking for myself, I truly value the written comments. Gives some time for analysis prior to the board meetings. I'm able to kind of compare different perspectives kind of next to each other. I'm able to, if I have questions about it, I kind of find answers. I appreciate the written comments, so please keep them coming. I think we ended up with just about 55 this time, which is a fantastic number. It's a great opportunity for y'all to speak directly to the board. So please continue with the written comments. Thank you to everyone that made public comment. We'll go ahead and move forward to agenda item 4. Starting off with our recap and summary and some new information regarding legislation that we were following during the session that just concluded. I'm going to hand this over to Daryl for his report.
All right. Thank you, Mr. Chair. Just to give everybody a brief update, we were tracking roughly 250 bills out of over 8,000 that were filed in this 89th legislative session. When we track bills, we track them based on, does it affect the agency directly? Does it affect the agency indirectly? And then does it touch upon the profession in any way, shape, or form? Those are the 3 categories that I track. What we're going to talk about here today are really the things that just affect the agency directly. It's the things that now we have to begin implementing that have been passed into law. But I'm also going to kind of go over, I know there were some bills that were of significant importance to the profession as a whole. I'm going to just kind of go over those and make sure it's clear everybody understands where that is. I know one of the public commenters had spoken about House Bill 3515, but just so that we're all kind of clear, that did not pass. That bill did not pass. Among the other bills that did not pass that I know were important to the profession are House Bill 1537 and SB 498. That's the counseling compact. Both that bill did not go anywhere. It didn't receive a hearing. Same thing goes for the social work compact, if any of you hold a social work license. The Medicaid reimbursement bill filed by Representative Darby and Senator Sparks, it died in Senate Health and Human Services. Actually made it out of the House, which was a pretty impressive achievement for a bill like that with a price tag attached to it like that, to make it out of the House. I was like, whoa, that may actually go the distance. And then it hit Senate Health and Human Services, and met its demise there. House Bill 4721 and Senate Bill 51 were both repeats from the 88th and 87th legislature. Those were bills filed by Representative Romero and Senator Zaffarini. They are what I term cleanup bills or updates for MFT, primarily MFT, but LPC and social work to some extent. They did not affect psychology. Those bills didn't receive a hearing, so they have died in committee. And then, of course, SB 1081, I don't know if anybody was aware of tracking that, but it was the Art Therapy Board bill. It died as well. House Bill, I think it actually, I don't remember if it had a hearing or not. I remember having to prepare a fiscal note on it, but I don't know if it had a hearing. Typically, we don't have to submit our fiscal notes until there's actually a hearing set on a bill. House Bill 11 was one that I was kind of pumped about because while the psychology board has reciprocity authority, in other words, the psychology board, I can negotiate reciprocity agreements with other states on behalf of the psychology board. I cannot do it for this board or the MFTs or the social work. Y'all do not have the specific statutory authority for it. House Bill 11 would have given you that. And for some reason, when the House committee, I think it's licensing and admin procedures, when they took it up, they stripped out all of the authority for us and all the other healthcare agencies, and TDLR was the only agency that left in that bill. I don't know why that occurred, but it was one that I was like, no, don't do that. I want that. But nobody reached out to us or anything, and so we lost it. But it was so close. We almost had that. But anyway, I just wanted to put that out there in case anybody was tracking it. So the gentleman that commented earlier about reciprocity, his disappointment in reciprocity, take it up to the legislature. That's where you're going to have to fight that fight. All right, now on to the good news, the stuff that passed. SB 1, which is the state budget bill. I'm not going to bore you guys with all the details of it. I've given board members, you've got a cheat sheet of everything that was passed. But in short, we were given our baseline budget. And most of our requests, one of our requests to fill some vacant staff positions, we were only given half the money that we requested for that. I'll just tell you right now, given the need for more litigators in the legal division to handle complaints, we're seeing more complaints at BHEC nowadays. And given the need to handle those, we're going to be using that money to hire attorneys. So that's where that money is going to go. I will also tell y'all the state is hemorrhaging lawyers right now. They cannot keep attorneys employed because the private sector is a much more lucrative draw for them, and nobody wants to work for the state for what we pay. So the ledge did authorize a slight 6% increase for all the attorneys in the state of Texas. The GCs and the staff attorneys in the state will be getting an across the board pay bump on that. But and that's an effort to kind of stop the hemorrhaging that's going on. But other than that, two other kind of quirky things that happened in the budget is we were awarded $125,000 to design a new psychology exam, not develop and deploy it, but just design it. I'm not going to bore y'all with the details of the fight that psychology's in over that. But we were also awarded or appropriated $200,000 to develop a Spanish translation exam for a social work exam. So that's going to be an adventure to figure out how to actually implement that. But that's it, Mr. Chair, as far as the budget goes. Anybody have any questions on the budget before I move on to some of the other bills? Okay. Seeing and hearing no hands. You look like you have a question.
No, I was going to wrap up for you.
Oh, okay. Sorry.
Any questions for? Okay. Let's be absolutely clear. Daryl took about 5 minutes that recapped 5 months worth of work.
Yeah.
And I don't know how much y'all understand what really goes into what's going, but imagine you're doing your full-time job, and then every 2 years you got 5 months to basically you double your workload. And this is my way of acknowledging all the hard work that staff did during this session, and maybe some special sessions coming up if it's required, but
go wash your mouth out with soap. Sorry, Mr. Chair.
Not to put that out into, not to manifest that, as the kids say, but Daryl, thank you. We know that you know, we just sit here on June the 6th and we get a report of what happened. But for you, it's calls, it's going over the Capitol, it's speaking with committees, it's the horse trading, I suppose, on budget. We do acknowledge the work that goes into a session. I've never seen one where we got exactly everything that we thought was beneficial, but I choose to focus on the successes that we did have coming out of this, and not to dwell on the failures or disappointments, but learn from it. A lot of times we see a certain thing that we believe would be beneficial, and it advances a little further each time. Sometimes it just doesn't work out, but thank you for sure on all that you did these past 5 months. Robert as well, Patrick, I know you were involved. So recognition for staff for everything you did here. It's like I said, you reduced all that work down to a 5-minute update, and we're just going to say, okay, let's move on. But no, we do acknowledge everything that went into that. Thank you. Okay. No other questions regarding legislative update? Then I'm going to go ahead and move forward with my board chair report. This is item 4B. The written version of the report is in the available material today, but I do want to take a couple things and speak on them. First, it was not in the written report, but I will take note that public member Sean Shakarami resigned his position from the board on May 28th. We thank him for his service while he was a board member. Want to say a thank you to Brenda Campanone, Vanessa Hall, and Jen Winston for their service on the board. Brenda was a long-serving professional member. Vanessa Hall was a public member who was inspired to seek out her licensure, and she just completed her master's degree from Liberty University. Dr. Amuna and I spoke at a recognition of her accomplishments ceremony. We're super excited for her. She was a very involved public member. We're going to miss her, but we wish her well on her journey to being a professional member. And who knows? I don't know if we've ever had somebody serve as a public member and then come back and serve as a professional member. She would be the first. So we wish her well, Vanessa. I don't know if you're listening, but congratulations. And again, on behalf of the board, welcome to our new professional member, Brian Eby. Unfortunately, he was unable to be here this morning, but our new public members, Elisa and Corey Rose. Thank y'all. And just literally yesterday, we had a new public member appointed, Nadia Stewart. She's a private practice attorney out of Round Rock. She does things similar to what I do. So of course, I'm very excited to add her to the board. So that is brand new information. Those y'all taking notes out there, her name is Nadia Stewart, and she is an attorney in Round Rock. Couple notes from the BHEC meeting back in February. Thank you, Dr. Stubblefield. She delivered the update report from the Children's Mental Health Strategic Plan Subcommittee. The BHEC reviewed and passed the proposed rule change to 681.72 on application materials, 681.140 on requirements for CE, and we considered and adopted proposed rule changes recommended by the quadrennial rules review. That was a lot of the initial stuff. I'm going to go ahead and put this out there, and they're going to correct me if I'm wrong, but we still have as far as I've heard, a target date for CE broker is September 1st of 2025, and everyone should be watching for instructions on that. And our next BHEC meeting is going to be October 14th. No, our next BHEC meeting is in 2 weeks. That's a correction. I got that wrong. Our next BHEC meeting is 2 weeks from Tuesday. 24th? I stand corrected. Next BHEC meeting is June 24th. Okay. Any questions for me regarding the board chair report? Any questions regarding BHEC? Okay, we'll move on to the board administrator report. Christina?
Yes, just a couple reminders. Again, when leaving a voicemail for staff, please try and include your email. It's just a little bit quicker for them to get back to you, and then it's something for you to have on record from us for your records. Continue to use the contact us form on our web page if possible. Also, the big one is allow staff at least 6 weeks before calling to check the status. Be sure to check your emails, your spam, anywhere else your emails could go. Just double check it and always make sure that you have your most up-to-date information online or on your file. I actually just got a call this morning and we've sent 3 deficiencies to someone, but the email they entered is wrong. And so we've been sending it to the wrong email this whole time. So it's really important. We can only go off of the information that we have on file for you. So it's good to just periodically go ahead and double check that. There's a link there that we have for you to go and log in and update your information as needed. So another big one we needed to just continue to remind, I know I'm a broken record on this one, but for supervisors that we really need to make sure that we're trying to get those supervised experience documentation forms submitted within 30 days of completing that supervision. Doesn't matter if you're the first, second, third, 12th supervisor, you've got to do yours within 30 days. It's not when they finish, it's when you finish with them within 30 days of you finishing supervision with them. We're fully staffed in LPC, which is great right now. They're working about a 3-week processing time. I think they're working applications received May 16th right now. So if you applied before that date, please double check your email. You may have received a deficiency from staff. And as Chair Haubauer mentioned about the CE broker, so yeah, there's a lot going on right now. The biggest thing I can recommend to everyone is make sure you're signed up for email updates. If you're here today, you probably already are, but spread the word. Any friends, any other associates that you know or whatnot, spread the word so that everyone knows, what's going on, because this is going to be a big change for everyone. And that's it.
Any questions for our board administrator? Hearing none, we'll move on. 4E is committee reports. Christina.
Yes, related to the Application Supervision Issues Committee, since the last meeting in January, they reviewed a total of 9 cases. There were 2 related to past criminal histories, 4 related to academics, 2 related to supervisor status, and then 1 foreign degree application.
Okay, any questions regarding the application and supervision issues? Okay, hearing none. We also have a committee report from the Rules Committee. Dr. Stubblefield, please.
Good morning, Chair. Just an update, the Rules Committee met on April 9th, 2025 to discuss rules being proposed today during agenda item 11B, which were resulted from the quadrennial rule review, which are 68191 on LPC associate license and 68193 on supervisor requirements.
Thank you. Any questions for the chair of the Rules Committee? Hearing none, we'll move forward. Agenda item number 5, report on performance measures. Christina, please.
Yes, so you all should have received the performance measure reports in your board packet material. If you had any questions on it, I'd be happy to try and assist with that.
My take out of that is I'm glad to see that we're going to be able to hire some additional staff, like keeping our response time, our resolution times up, and it's great to see that we're just growing our group and continuing that really that resolution time that is just we worked so hard to get up and be operating so well. And as our mental health workforce grows, our staff should grow as well, so that we can continue that high level of response that you guys are so good at. So great to see that. Okay, and I think we can get one more in. Agenda item 6. We're talking about digital license and optional printed wall certificates.
So staff are working on a new configuration on how the license certificates are issued. So currently when a new licensee is eligible for a license, they're going to receive an 8x10 certificate. What we're hoping for in early 2026, all licensees will have the ability to obtain a secure digital certificate. And then if they are wanting a printed one, they can purchase it. It would be an 11x14, the big pretty one, that size certificate. So that'll be something that is available for purchase, but we don't have the price set on that yet. So more information to come. Please, again, I'm going to be a wheel here, but make sure you're signed up for email updates because that information is going to be sent out in that way.
And I think part of the point is that these won't be up anymore. These will be able to be downloaded. But if somebody does want a mailed wall certificate, they could order this. This comes from the Texas Print Shop, so we don't actually do it in house. So we'd have to order it, and they would create it. You can get a bigger, fancier looking one.
For the initial license, do they get the 8x10?
It's only to so it hasn't happened yet, and they're working on making this so it's something that can be securely downloaded and you can't edit it, that sort of stuff. But this would not get mailed out. This would just be something you could log in and you could download it whenever you need it. You wouldn't necessarily have to keep requesting a copy and paying money for this to be sent, unless you wanted the bigger one. That's the one you'd have to.
Okay. And
pay
what
for.
about the renewal cards?
We haven't been sending those out for
But is it possible to get an electronic
renewal card? No.
Yeah, so currently you just print what's online, the verification page. It provides everything on that page that would be on that card.
I think part of the license design is it used to have an end date and it doesn't anymore. It just has I think initial date here. So it just says it's good since this date, and so it continues on.
That was my question for the wall, the nicer one. Does it not have an end date? Because sometimes if you have something framed, you got to take it down, put a new one on.
No, it just has the initial.
Perfect.
The initial one. This is what psychology gets, and so we were offering it to all the other boards so that they could get the same sort of bigger.
How much do those cost?
I don't know the.
We don't know the price yet.
Okay.
You're going
But
to decide that later.
We don't determine it, right? That's the
BHEC does.
BHEC does.
In the fee rule.
Okay. Well, I'd like them to be as cheap as possible. I want all of our professionals to have a nice certification up on their walls.
I think it also depends on what the house printing charges. So.
Okay. Gotcha. We're gonna discuss it at BHEC or?
I don't.
Yes. Okay.
In June. Oh, okay.
So on the 24th, they will be discussing it in the BHEC meeting. If anyone wants to join and listen in.
I think I remember it's on the BHEC agenda for June 24th.
Okay. No, I'd like that to be as easy and as cheap, really, as we can get it. Affordable. I'm sorry, affordable.
I can make it cheap.
People have spent a lot of money to get that piece of paper already.
Dr. Bradley had a cheap ride over here today. Look at that guy.
Took two attempts, but okay. I think this is a good time for a break. So we're gonna take a 5-minute break and then we will come back. So we stand adjourned at 10:25 a.m. We will reconvene at 10:30 a.m. Welcome back, everyone. It is now 10:37, and this full board meeting of the Texas Board of Examiners of Professional Counselors is now back in session. Agenda item number 7 is the nomination and voting of a public member to serve on the BHEC Council. I currently hold this position as the LPC public representative at BHEC. I'm happy to continue doing so. If I have your support and your confidence in my work on the BHEC board to this point. But I am professional enough to open this up for discussion about whether a different public member would be would better serve the LPC interests at the BHEC level. So I will open that up for discussion.
If you're willing to serve, I'd be happy to nominate you.
And I second. Third.
Well, thank you. We have a yes, Dr. Bradley. Not only would I be willing to serve, I'd be honored to serve as the BHEC representative.
Well, I think you're doing a good job. So,
well, thank you very much. We have a motion and a second. So is there any discussion to appoint Stephen Hallbauer as another term as the BHEC representative?
I think I just want to say thank you, Chair, for your service and to represent our board to BHEC. Thank you.
Thank you. Like I said, it's an honor to do so. By this time, we're still adjusting. We're still learning the nuances about the relationship between the LPC board and BHEC. But being involved at that level, I feel has made me better at kind of understanding the dynamics of both organizations. So, like I said, I'd be honored to keep doing it. So at this time, I will call for a vote for me to continue to be the public member at BHEC. So all in favor, please raise your hand. And Corey? All right. Thanks, everyone. Always a little awkward. No, I'm happy to continue doing it. Number 8 is licensing matters. Christina, please.
Yes. Okay. So today's licensing case that we're going to hear is for Josephina Cali. The board packet, the material was in your board packets. And the issue with Ms. Cali's application, it's a foreign degree. The evaluation companies were unable to distinguish between the bachelor's level courses and master's level courses in order for staff to verify that she's completed the minimum 48 graduate hours per statute. So at this time, that's where staff were not able to move forward with her application, but with right to due process, she's able to appeal to you all to review her application further. So I can answer any questions, and let me see if she is on the Zoom call, which I believe she was going to.
Is she there?
She is here.
Okay, before we hear from Ms. Cali, any questions? Dr. Bradley?
yes. At the time, she would fall under the 48-hour rule, but all 48 hours must be graduate hours because in reviewing it, I couldn't tell what's undergraduate and what's graduate.
Dana, my question, I know you have this wonderful spreadsheet about the states that have equal to or greater than rules. And so because this individual has been licensed in New York for 19 years and Florida for a couple of years, can you speak to that? My recollection is that at least New York is equal to or greater than, and I think Florida is also. Do you know?
That I'm not sure. And again, the biggest issue here is not related to like the board rules for those other states, which is what I've looked at in the past. In this case, I don't know if that was the statute allowed them to bring her in a different way. Our statute for Texas does not.
And I can say that just after reviewing, thank you, Christina, again, for being awesome. There are some states like Florida and New York, some have the 3,000 hour similarity, and there's a K-cap requirement that we don't enforce or we don't have. But that's not withstanding the actual courses. And so again, my concern was like, wow, okay, you're already licensed in 2 other states. You've been licensed for a long time. The requirements are more stringent than ours in some places, but you've already had to pass or overlook the course requirement. And so we don't know if they cared or looked at your courses, which is a key factor for us. And so even though there's already a licensure and you've already, exceeded requirements, it's their baseline for a course requirement may not be like our baseline for a course requirement. And so that's the challenge.
Yes, because she also, based on the evaluations, she holds a counseling related degree. So we would also have to verify that each of those individual courses were completed at the graduate level, which we are not able to do.
Okay, Christina, to your recollection, have we ever had this degree from this university in the past?
That I do not know, but I will say we have had 2 other cases come before the board similar to this related to statute and not being able to verify information enough based on the evaluation company. And she did go to a second company in an attempt to try and get more information for us. Unfortunately, even that second evaluation company was not able to provide additional information that would help us be able to verify the hours and verify the courses.
Christina, for continuity on those earlier cases, do you recall what our decision was?
Yes, we made them go back to school and get the courses or a new degree.
Okay. Okay, any questions before we hear from the applicant?
I have a question. So in the past, the previous applicants will have to go back and complete the entire requirements.
One of them did have to, one of them was denied based on the degree, and they would have had to go back and get a new degree. I cannot tell you if they are in that process or if they decided to take a different route. The most recent one he had to go back and get 12 additional hours. He went back to school and completed those and is now licensed.
So in her case right now, it's not a degree issue. It's more about graduate courses.
Yes, graduate hours and courses. Yeah.
Okay, thank you.
But correct me, are we not sure how many graduate hours that she would need?
We know they would need 48 based on when they began their counseling related degree.
Okay. Okay, let's go ahead and hear from the applicant. 3 minutes?
Yes.
Okay.
Ms. Callie, are you there? Can you try and unmute? There you go. Oh. Can you try and unmute yourself?
Okay. Can you hear me now?
Yes.
Yes.
Excellent. Okay. Can you start?
Yes, go ahead.
Okay. Good morning, esteemed board members. My name is Josefina Cali, and I appreciate the opportunity to speak with you today. Thank you for the time and thoughtful attention to review my application. And I also want to thank Ms. Cristina Di Luna, who has been assisting me throughout this process. I come before you with great respect to request your reconsideration for the approval of my mental health counselor license in the state of Texas. As reflected in my documentation, my life has been fully devoted to the field of mental health. I bring 47 years of professional experience, including 22 years of licensed practice in New York, during which I have supported thousands of individuals facing complex emotional and psychological challenges. My background includes clinical work, diagnostics, supervision, academic teaching, community outreach, and media appearances in both Argentina and the United States. Mental health has not just been my profession, it has been my purpose. That journey began when I was just 10 years old, founding a children's association in my hometown in Argentina. That early experience awakened in me a calling to serve, one that has guided my entire life. In Argentina, my academic training in psychology was rigorous and extensive. I completed a 6 years intensive of unified program at University of Buenos Aires, which, though structured differently from United system, is equivalent in depth to a master level education of United States. We graduated not only with a bachelor degree, but with the title of licenciada in psychology. So that's why we don't have graduated and undergraduated. You know? I currently hold active license in the states of New York and in Florida. And I want to add that in the first evaluation, I think I have 164 or 66, I don't remember exactly the credit hours. And in the new evaluation, I have 186 credit hours. I currently hold active license in the states of New York and in Florida, and I also passed the National Clinical Mental Health Counseling examination in December 2022 under the newly updated and stricter national requirements. What I bring to Texas is more than just credentials. I bring a lifetime of learning, a proven track record of compassionate care, and a sincere desire to serve this state with integrity and excellence. For 5 decades, I worked with deep responsibility and commitment, guided by ethic, humility, and a reverence for the human spirit. I come from generation of educators and scientists who instill in me a strong sense of public service. Continue this work here would be both an honor and a personal milestone. I know I have so much to offer. My wish is to invest my knowledge, wisdom, experience, and heart in helping individuals and families in the state of Texas, especially those suffering in silence. I respectfully ask you consider not only my documents, but the story they represent, a life of study and service. Thank you again for your time and your thoughtful consideration.
Thank you, ma'am. Please stay on. Dr. Bradley, question? He was waiting.
Okay. My question, this is a statute that she has to have 48 graduate hours. If we can't determine that she has 48 graduate hours, I don't see that we have any latitude here, do we?
Is the question about the number of hours or whether they are graduate or baccalaureate level?
Graduate.
Okay, so it's a question of whether they are graduate hours.
Both. I mean, are there 48 equivalent or appropriate graduate hours?
Yeah. When Patrick just showed me the foreign degree equivalency evaluation, and the way it reads is bachelor's and master's level. I thought it had said, I was thinking it was saying bachelor's or master's level. Now, I'll tell you, I don't know anything about this applicant, haven't read it, so I'm kind of spitballing here, so take it for whatever it's worth. But if the foreign equivalency says and bachelor's and master's, I think if you couple that with that rule you just pulled up, the 2-year, I think you could say, okay, we think maybe she meets the degree requirement, but if you're still uneasy, I think under the remediation rule, you could say, look, to shore up any concerns we have about coursework, we're gonna set these type. You got to go jump through these hoops, do these extra things in order to satisfy or assuage any concerns or fears we might have. I think there might be a pathway forward if you want to do something. It really is going to boil down to whether or not you all think. I think whether her degree is a master's level degree. Because if you think it's bachelor's level, she's out. There's nothing you can do. That's a statutory failure, and you can't cure that.
Right.
But if you think it is a master's level, but you're concerned about the coursework, well, you can cure that through the remediation rule.
Yeah. Sorry.
Ms. Sam, yes evaluation, where at the asterisk in the bottom it says that due to the unified nature of this program, it is not possible to differentiate between undergraduate and graduate study. And they spend their life evaluating programs and degrees, and we don't. And so I don't know how, if we operate within our scope, how we can go through this and say what's graduate and what's within our scope.
And I kind of said that same thing in the beginning. I could not determine.
If I could add, the statute 503.302 does talk about the applicant has to have a master's in counseling or a related field. And then it also says must have completed not less than 48 hours. So the difficulty we're having, right, is that there is a rule that says then if somebody's licensed in good standing in another jurisdiction, so she has another license, they were deemed to have met the requirements. The problem is we're looking at the evaluation, and the evaluation, it just says we can't distinguish what's graduate and what's undergraduate, and so that's where we're stuck with. I don't know that the statute we can't change, the rule we can remediate, and the rule does say we can count those. The problem is we're deeming them to meet it. The problem is we know that we can't verify that she is actually meeting it. I guess that's the rub.
If we were to accept a master's of psychology, what would be our next course of action?
So you can say it's a related degree, and it actually, I think under the rules, is considered a related degree. The issue will be it will have to have the 48 hours of graduate level coursework, and then there's a rule in there that says the rule that lists out all the coursework requirements. Since this is prior to the 2017, it'll be the shorter part of the rule, not the longer part. So we would look for each of those types of coursework. Now, because she's licensed in another state, we could then use that rule to say, since she is licensed, she's deemed to meet all the academic requirements. So I don't know that we'd have to necessarily go through all of them. With that, it's the rule is 68182C. It says if you're licensed, fully licensed in LPC and in good standing in another United States jurisdiction for at least 2 years, you're deemed to meet all the academic requirements. So we wouldn't necessarily have to do the course requirement evaluation at that point. We could probably use her prior license. Problem is, the evaluation doesn't give us the information we need.
Okay, Dr. Bradley.
I'd like to know from Christina or staff, how did this end up here with the board in the first place?
So this was reviewed by staff. We tried to get an additional evaluation, try and resolved it, internally. Because the applicant has right to due process, she is able to appeal the denial to you all, to the full board for a final review or for further review. And she still would have, if the board determined to deny her today, she still has, right to due process and can appeal to SOA. If she chooses to. But again, this was something that staff was not able to resolve, and she has right to due process.
Okay.
Certainly, I agree with due process, but I was just trying to determine, so staff essentially said the same thing that I said here in the beginning.
Correct.
Okay.
Okay, my curriculum authorities, taking a look at the credits for the classes that she has, are these typically undergrad classes, or are they typically master's level classes? This is I'm looking at the
IEE or
WES report.
Well, there's intro to philosophy, intro to sociology. There's no way to determine that. Biology would typically anatomy and physiology, fundamental psychology. I would think that's undergraduate mathematics. But again, I don't feel competent doing this evaluation. I evaluate transcripts for
Okay.
people transferring to Texas Tech at the doctoral level, but I know it's a graduate course.
And there's nothing.
There's nothing here when I looked at it earlier. Group dynamics and techniques, I'd say that's probably a graduate course. Projective techniques, I would think is graduate. Clinical psychology, again, you have undergraduate degrees. I would think most clinical psych courses are graduate, but I don't know that for sure. English language, that could be either. French language could be either.
Yeah.
So
I'm-
that's what I was trying to say in the beginning. I can't determine if they're 48 hours.
What does New York and Florida do differently that allowed her? Do we know?
I don't know.
Okay.
I'm assuming it's their statute may be a little more lenient to allow them to come in, but I don't know because our rules isn't what's preventing us from licensing him or having a remediation. It's the statute. We just can't verify those hours at the level that statute requires.
Okay.
I don't know when the applicant was licensed in Florida, but I know that Florida has something called mobility endorsement now, which would negate all of this analysis. In other words, Florida just looks to see, are you actively licensed in another state? You got any problems in your background? You clean history, in other words, are you a known quantity? And then they give you a Florida license. So they would not have had to do all of this. Florida wouldn't, if she came in under that mobility endorsement provision. But I
Okay.
don't know that. I don't know that she did.
And I've had that Florida rider. It is relatively easy to acquire, but the New York license is what I'm looking at because I pulled their application and I don't know when she applied because she's had that license for a couple of decades, what the rules were then, but I know right now it requires passing both the NCE and the
NCMHCE.
Thank you, NCMHG, ABC, both. And because I only took the NCE, I don't qualify for a New York license.
And again, I think timing for me as well, because New York requires KCREP accreditation to be licensed. And so depending on when the license was obtained, if this individual can show that they met KCREP accreditation, that might give a little bit of teeth to our statute with regard to the hours. But it's about timing of the licensure and the requirements in New York at that time. That's the closest pathway that I could probably see if they fell under KCREP accreditation when they apply for their license in New York, because then that would almost supersede our requirements.
Can we do that?
Mr. Chair, are you wanting us to look at New York, and we'd have to look to see when she was licensed and then look at the law in New York that was in effect at that time? Is that what
Do
you're
we
wanting?
ever do that?
Yes, we have done that in the past.
Okay.
It's rare that we typically require the applicant. We say, you go get the law that was in effect at that time so that we're not having to do this kind of legwork.
Okay.
Full New York license, 2006. That's 19 years. I don't know if it was KCREP a requirement in New York at that time. I won't presume.
Just ask her.
I would like to verify through the New York board if
No,
they're,
You
no,
can ask her.
I agree, but I'm just curious to see, does she know whether, Ms. Kelly, do you know whether or not when you applied for licensure in New York, did you have to show some equivalence to KCREP accreditation with your degree?
I remember that I did evaluate the first evaluation of New York. There was a bachelor and master's degree. And they know that it was difficult to identify graduated and undergraduated because we don't have this unified system. And I got the license in New York in 2006. At that time, they also compensated with all the time and endorsement of supervised hours. And I present like a more than 8,000 hours. So now I have like a 10,000 hours supervised, more 1,000 hours in other clinic, a lot of supervised hours in New York. And also
Do you remember them mentioning the word K-CREP though? Is that ringing a bell whenever you had to apply in New York?
What word?
K-CREP?
No, it's the first time that I heard that word. No. And also I didn't tell I have a diploma of honor because I have my GPS is the 3.67. And we don't have in Argentina, it's a unified system. So I understand the difficulty to graduate and undergraduate because we don't have. Right away, when we finish high school, we already hold a bachelor for high school because it's more years than here. Here, the high school, secondary school is shorter. We have longer, and we got a bachelor degree in humanistic after the bachelor degree until we go to the university, and it's very intense since the beginning. It's very profound, all the subject. So we don't have that system. So it's like a talking, I know the difficulty, but it's not graduated, undergraduated, because we don't have. Now in Argentina, they are talking more about completing a master, but we don't have. We can do even a PhD. If I complete study, I will complete a PhD in psychology, again, to do the master's degree in counseling. I study a lot. And I was a professor at University of Buenos Aires and University of Comahue of Patagonia. I taught for many years. I'm an expert in Rorschach test. You can see all my records. I send to you all the information of my resume. It's very broad, different areas, very deep that I go in each subject. I'm very perfectionist in my profession. That's coming. My father, he was a medical doctor, mother teaching, and it doesn't matter to talk about my family, but I'm saying I'm very insistent that everything that I have to do has to be according to the law, of course, and according to what is related to my profession. But I understand your issues.
Hang on just a second, Miss Kelly. Okay,
yes.
Jenny?
I would just say, Ms. Callie, you have very impressive credentials, but we do have statutes that we have to follow, and that's what we're looking at. How do we follow the statutes that we have in place? That's what we're working on for you.
Yeah.
Thank you. Thank you so much.
My public member hat is saying that I don't think giving this lady a Texas license is a risk to the public. My lawyer hat is telling me that we're handcuffed by the statute, and if there's no way around the statute, then that's the answer. But if none of the board members have ideas around that statute, then again, we're kind of handcuffed. And staff, if we have no options to consider, then unfortunately that's the answer.
Is 68172C not an option?
So I think that was part of what I was talking about. The issue is we can't modify what's the statute in 503.302 says. And what that says is you have to have a master's or doctoral. And then it says has successfully completed the degree that it's no less than 48 hours. And so yeah, so the evaluation says, it says, it's very odd because I haven't really seen evaluation like this before. It says she's done a bachelor's plus master's, and it doesn't really and then it says we can't differentiate. So I think from that we can probably infer, okay, there must be a master's at some point in psychology. The problem is does it meet the 48 hours? Because we don't know how many of the hours are in there. And so part of what that rule is talking about is we were assuming somebody is, you know, their license in another state probably meets the 48 hours. The rule that you're talking about, Dr. Stubblefield, 681, was it 92?
70.
82, sorry, C.
And I'm
681.72C.
and I'm on the New York licensure website now, and their asterisk at the bottom fine print says that a program must be accredited by KCREP under 2009 clinical mental health standards. So that seems to be the year that they implemented that KCREP as a requirement. So any degrees or certifications or programs prior to that may not have been subject to KCREP.
Miss Callie, do you remember, were you grandfathered in?
Sorry, excuse me. What did you ask? Sorry?
Anything. Yeah.
Do you recall if they ever mentioned like the word grandfathering you to come in and get licensed in New York? Did they grandfather you in? Some states use that terminology.
That was, but I don't remember in my case. I present all the documentation and also the endorsement and the supervised hours. The endorsements were with the supervised hours. And they put all together, but plus the years of experience that I have, because at that time when I came to United States, I already was long years in my profession. I decided to come to this country because I have many plans for my professional life, and I'm still, even older now, I'm still going up, but I don't remember more. I would have to read again and again how was the, in the application, you know? I don't understand. I don't remember. But like I present all the documentation plus the endorsement. I remember the word endorsement and the supervised hours. A lot of supervisee I have in the clinic. I worked for more than 6 years. And the hours credit that I have in the evaluation is like 186 hours. And in the other evaluation, 160 something, 64, 60. I don't have all my documentation in front of me, but it's a lot of credits hours. And many courses and courses that I continue study here in continuing education. We have many.
Chair.
Yes, continue study, you know.
Patrick, you just mentioned earlier that because she holds a license in different states, and then there is some, what was the other potential that you just mentioned to the board? Another round?
There is a rule that talks about deeming them to meet the requirements when they're licensed in other states. I think, I don't know if that one necessarily applies for her. Let me look a little closer at that, but were you going to say something, Daryl? I think Daryl.
Look, I'll go out on a limb and say, I think 681.72C, if you want to do this, that is your avenue to do it, because that rule is if you're applying for the LPC and you hold an LPC in another jurisdiction, you're actively licensed, you're in good standing, we will consider your academic and experience requirements met. So I will admit her degree is problematic. If we were looking at it absent her licensure in New York or Florida, her degree would be problematic and it might not get her in.
So I guess my question, Daryl, is from the staff recommendation is perhaps this particular rule will not apply, could not apply because of the statutory requirement of the degree of the graduate.
Correct.
Am I hearing it correctly?
Yes, ma'am.
So I don't think we need to consider this particular rule. Is that what I'm hearing?
Well, no, we're playing both sides of we're talking out of both sides of our mouth.
Okay. I want to understand. I'm not in this,
We're actually punting it to y'all because we cannot decide at the staff level. We've looked at it and looked at it, and to us, we're not comfortable giving her the license based off of the documentation we've been provided.
Okay.
We don't feel like there's.
I agree with you on that one. It's just when Patrick mentioned about this rule confused me a little bit about are we having another, so.
Yeah, there is a rule that allows us to kind of not have to look at the academic and experience requirements if you've already been vetted by another jurisdiction. And
I
that's the
see.
rule he's talking about there.
I see, but, okay, got it. Thank you.
And with that, I am done talking.
Janie, did you have anything to add? I think our hands are tied as well. Does anyone disagree with that? That we reviewed every possible option that we have, and we still come to the conclusion that it's bound by the coursework requirements, and that we can't what the ledge has put in place, the board cannot override. That's essentially it. So, board, is there any further discussion on?
I would just say that once we make a decision and vote, would we be willing to offer information on how this applicant can move forward after the vote?
Sure.
Okay, thank you.
Yeah. Okay. Then, board, I do need a motion on whether we deny the appeal. It's a denial of the appeal, correct? Yeah. And is anyone willing to make the motion?
I'm not on the applications committee, but I'll make so moved.
Thank you, Dr. Stubblefield. Is there a second on the motion?
I'll second.
Okay. We do have a motion to deny and a second. I will entertain any discussion. And Corey, I apologize. We keep forgetting to check with you. Do you have anything to add to this? This is kind of a throwing you in the deep end on what the board considers. And like I said, in my directive, speaking to the public members, it's our job to say, is this right? This looks a little strange. Do you have any questions on our discussion that we've had? I'm sorry that I haven't checked with you.
No, that's okay, Mr. Chairman. Thank you. The only thing I would say is, I mean, I think I agree with everyone that we're failing to meet the 48-hour standard, but I would just second the comments of, if there's a way that she's clearly, in my opinion, a very qualified candidate outside of that statutory requirement. So if there's any way that we can provide, some guidance on a path forward, that, determining how many hours are remaining or what have you, so that we don't just leave her kind of lost for what the path forward is. I think that would be helpful on our part.
Okay. The path forward is to find a program that will consider a lot of the previous coursework and then tell her how much she has remaining in order to get a master's degree. Is that correct? Yeah.
Yes. And
Okay.
I'll reach out to Miss Callie also and work with her closely on options that she may have.
Okay.
Mr. Chair, if I can add, a second pathway might be if she could get an evaluation done of her degree that differentiates. This is considered equivalent to a master's degree in the United States. And these are the courses that she took. So we can count which courses those are and how many credit hours those are. That would be something that we could look at as well.
And
yeah.
Do we have any parameters on what we would accept?
I mean,
the dean of the university in Argentina writes her a letter and says these are in 1973. These were graduate level courses. What can we accept?
Yeah, there's under one of the BHEC rules it talks about for foreign degree evaluations. It's a NACIS, I think, is the acronym accreditation. So it's any sort of organization that holds that sort of accreditation or a similar accreditation. I'm trying to pull up the rule real quick, but any of those organizations, if they can do that. The problem is she's got two. She tried twice and they weren't able to do it. She could find one that does do that. That would be extremely helpful.
Okay.
If the issuing institution would do it in English, we would accept that as well.
Okay. Say that one more time, Daryl. I wanted to hear that.
Official transcript. If it's translated to English by the issuing, let's see. Is that, hold on, that's the translation.
The rule is 882.11 is applicants with foreign degrees. And in that, it talks about evaluations of it and what sort of evaluations we would accept.
Okay, Christina, you can direct her to that.
Yes,
Okay.
we'll continue to work on it.
Okay. Well, thanks, everyone. Dr. Bradley, go ahead.
Okay. Mr. Spinks, you said something there, if something is translated.
Yes. The same rule that Patrick just spoke of. I thought the rule had read if the issuing institution provides you with an equivalency evaluation, we'd accept that. But it's actually a translation. If the issuing institution will translate it into English, we will accept that translation. But it looks like we only take evaluations from the list of providers that Patrick just mentioned: NACIS, AICE, the National Register of Health Service Psychologists, and for social work.
And did I hear someone say she's tried 2 different times and has been able? Because when I looked at some of those courses that I read out, I would venture to say that some of them have the same title as some of our undergraduate courses have. Now, again, I'm back to where I was my first statement. I could not evaluate graduate from undergraduate.
Okay, is there any further discussion on the motion? Okay, hearing none at this time, we will go ahead and vote, please. If the motion is to deny the applicant, and all those in favor, please raise your right hand. Okay. The applicant is denied by a 6-0 vote. Ma'am, we're sorry, but we encourage you to keep working towards this with some additional information, and you're going to get some guidance from Christina. But we wish you well, and we wish you good luck, and please be persistent about this. Thank you. Moving on, item number 9, examination matters. Christina, you were going to speak regarding the jurisprudence exam.
Yes, so you all were provided with the information related to the jurisprudence exam, just feedback from those who have taken the exam. Overall, many people enjoy it as a refresher. I know we did have a comment earlier about it is a free exam. Some people do mention that they do appreciate that, but that this is a good tool for a refresher. And then also that they like how the rule does populate after for them to know where to find the rules. There were a couple comments that I did get this time related to the rule may not be the correct answer or whatnot. So I'm going to definitely look into that. And then also based on the last couple of times that we've had some rule changes, I'm just going to go back through and see if there's any need to make those updates to it and then reach out to the Professional Development Committee if changes are needed.
Okay. Board, any questions for Christina?
I would just say I greatly appreciate those comments that you provided regarding the jurisprudence exam. It helps us to kind of evaluate the work we do going forward. Absolutely. Yeah, over 6.
600. Okay. Christina, the 9B, the performance report.
Yes. So this is the first of the annual performance report related to the NCE and NCMHCE. So again, it's just informational for the board members related to those who've taken the exam and the pass fail rate related to those individuals. This does not, I believe it does not count those who have had to retest. So you'll have those to consider in those numbers as well.
Christina, do we have any applicants that take the NCMHCE?
We do.
Oh, okay.
Okay. Any additional questions? Okay, hearing none, we'll move on to item 10, enforcement matters. 10A is SOA matters. Christina confirmed that we have none for today.
There were none.
Thank you. And 10B, Possible agreed orders confirmed that we have none for today.
None.
Okay. 10C, we do have a matter that came out of an ISC that we do need to review and discuss. Board, I'm going to give you just a couple minutes to take a look at the case summary provided, and then we will begin our discussion. This case number 2023-00142.
And Mr. Chair, if you'd like for me to give a summary, anything I
I
certainly
will.
can.
I wanted everyone to kind of take a look
Read
at
over it first? Okay.
at the discussion, and then I'm going to have you do it.
Sure. Just let me know.
Just a reminder to our new board members, because it's an ongoing or still a pending complaint, we can't use any names in the open meeting. You'll just have to refer to them kind of generally as respondent or complainant.
Respondent.
Yeah.
Okay.
Can you confirm that I do not need to recuse my? can't even
You
say
do
that.
not.
I do not. Okay.
Mr. Chair, the document you are referencing, is that backup document for Agenda 9C? Okay, so that's,
Yeah.
I read that, but I'm not sure whether I have an understanding, what is the original case? It gave the summary about, I guess, the respondent plead guilty to a felony case, but exactly what was that felony?
We'll tell you what, Patrick, why don't you go ahead and lead into
Yeah.
the introduction on our discussion.
Sure. So complaint was open because the licensee was convicted of Medicaid fraud they pled guilty and received deferred adjudication to Medicaid fraud. It was a second-degree felony, and they're in 5 years probation.
I understand, but I'm saying exactly what that fraud was a billing issue?
Oh, I don't-
Or
I-
it was what issue?
I don't know the specifics. I don't have the specifics in front of me. We do know that the person is currently pled guilty to it and currently is on probation for it. So
I think there's a difference, to me, there's a
Right.
difference between, actually character flaw, but still, there is a difference when you have falsifying patient's documents versus it is invoicing,
Intent.
financial,
Yeah.
I would like to understand a little bit more.
Sure. So one of the difficulties in having this discussion in open meeting is that sort of information you would get as a board member sitting on an ISC, which would be confidential. In this instance, we're not necessarily bringing you that information. The reason why we're bringing this to you, the board, is that under the council's rules, a complaint can be dismissed if an ISC panel recommends dismissal. That goes to the executive director. The executive director, under the council's rules, has the authority to dismiss it. Typically, that usually there's an agreement on that recommendation. In this instance, there was not an agreement. And so staff did not think that dismissal was an appropriate route to go in this instance. And so staff isn't recommending that the ISC panel is recommending the dismissal. And so the next step in the council's rules is the board can dismiss. And so what's before you is, do you want to dismiss or do you want it to go forward?
Patrick, please explain to our new members what an ISC panel is.
Sure.
It's one person. It's not.
Yeah. So I say ISC panel because each board does it differently. And so psychology will sometimes have 3, some other boards will have 2. LPC typically has 1, so it's a panel of 1, but it's in this instance.
Yeah,
but
I think that's important.
Yes, correct.
Because
Yeah.
it's one person's opinion.
Right.
I have a further question. So, but when staff review it, you do have more information.
Correct.
Okay.
Yes.
Because we are not, we don't know exactly, but you do know.
We're trying not to give you that much information.
Understand, but when you review it, you have that information available.
We have the criminal documents, the
Okay,
records.
got
And
it.
the ISC panel has an opportunity because staff is also present during the ISC panel. And so they're able to discuss with the respondent and the complainant, as well as review any documentation relevant to it. So all of that information is there. The reason why we're not providing it is if the board decides to not dismiss and proceed with moving forward, investigating and possibly disciplining this licensee, we wouldn't want to give all of that information to conflict the rest of the board
Sure.
out for voting
Sure.
on that later.
This is very important information because that make my decision clear.
Yeah.
I wasn't clear before, but now I know what I would like to vote.
Okay.
Okay, thank you.
Patrick, where would this be on the matrix? Like whatever the code was that they, you know what I'm talking, on the penalty matrix?
Correct. I don't know that there's a specific one because typically it falls under one of the rules that says following laws and laws that relate to the practice. And so because there are so many laws you could violate that relate to your practice, there's not like if it's this statute or that statute. So there's not I don't know that there is I have to go double check, but I don't think there's a perfect.
But we have a statute that they failed to report that the.
Oh yeah, the failure to
Yeah.
report is another one. Yeah, I can. Let me pull that one up. Sorry.
If you're allowed to tell us, and when it says fail to report in the time frame required, do we know when it was reported, like what that time frame was?
So I think I can tell you that the complainant is the agency, and the agency opened it up because it wasn't reported.
And so, okay, so they did not individually come forward and say like, hey, let me volunteer this information myself. It was just found out.
I can tell you the agency had to open the complaint to ask about it because it was not reported.
That's all I need. Thank you.
Yeah.
Dr. Bradley, go ahead.
That was partially my question. Did the person report it out of, when we think of moral development, in other words, they got to thinking this is wrong, or sometimes someone else reports it. And it sounds to me like you answered my question, that they did not come forth, that someone else reported. It also sounds to me like that staff is uncomfortable with the ruling, or it wouldn't be coming to us.
Yes, so the IC panel makes a recommendation. So when you say ruling, it's a recommendation. It's not necessarily a mandate, right? So and that's why ultimately the executive director under one of the rules, there's certain things he can dismiss under. So that's why staff is not necessarily making a recommendation as to what a particular sanction should be. All it is a recommendation of we should proceed with further investigating and further looking into possibly discipline as opposed to just.
And I wasn't interpreting that staff was suggesting a decision.
Mhm.
What I was interpreting, we get so few of these that immediately my antenna goes up. And that's how I concluded, okay, staff is uncomfortable with this, or you wouldn't have sent it because you don't normally do.
Right. Yeah.
Okay.
And Dr. Stubblefield, to answer your question, the failure to report reciprocal discipline falls under the administrative penalty matrix on the BHEC rules. It's 88432.
Dr. Bradley, the way I'm looking at this is staff is asking us to basically make a determination. Are y'all really okay with this? Because this is a little bit, not just a little bit. This is in their opinion, this is a little extreme on the recommendation from the ISC panel, and therefore, staff wants to make sure. Look, just kind of one person decided this. Full board, are y'all really okay with this? And that's how I'm taking it. And they're asking us, are y'all really okay with this? And
Well, I can tell you, I'm not okay.
well, the issue, what's a little kind of frustrating is maybe at an ISC panel, we have this much information to consider. We have a smaller amount of information to consider. But am I correct on that? Yeah.
Yes.
I'm not blaming the panel.
Yeah.
No.
I try to put some of the reasons why the panel recommended it in the summary sheet because there's some general thoughts of why they wanted to go that direction. I just also wanted to add to Dr. Stubblefield's question that the penalty matrix was just for that one rule. It's not necessarily for the actual violation.
What's the
That's
rule again?
the failure to report rule is the 88432.
That's address and name change. This isn't.
884.32. Yeah, under the BHEC rules.
Reportable legal action. Yeah, that's duty to update name and address.
Can I? You want to look? I don't.
I could see why that would be an administrative penalty, but failure to report. 80. Oh, am I looking at the wrong? Oh, I'm looking at the wrong thing. Sorry.
But there's also a reciprocal discipline or also the legal violation of committing fraud that relates to the practice, and so there's additional violations. That's only just one of the violations that.
I want to provide a little hopefully is some helpful background to specifically Corey and Elisa, our new members. Once upon a time, all disciplinary matters were just kind of heard in a meeting like this. There was recommendations that that's not the best way to resolve things. And so we moved to what is essentially ISC, Informal Settlement Conference. That's your opportunity to plead your case to one member of the complaints committee that gets to take a look at your case and then make a recommendation on a punishment and see if it can be settled at that point, essentially privately. But when you make that exchange between just every complaint being reviewed by the full board to going down to one single member, at that point, you still have to have some checks and balances because that's a lot of authority going to a single person. And the check and balance has kicked in here because that person, now staff is hesitant, and that's why the recommendation is coming to, again, like, it was kind of like a failed an appeals process, if you will, and therefore they're asking for a what's illegal, an en banc decision, or is it en banc at the full appeals board as opposed to just the usual smaller amount. And that was done for a variety of reasons, but this is kind of like the system being triggered for the board's information. We should know about these kinds of things, but also for staff who have their opinion on how something, whether like just kind of taking a look at the facts of the specific matter would typically result in a certain decision, but this one is out. Well, what are the reasons that it's outside of that common resolution? And that's why we're looking at it. We don't do these at every meeting. This is kind of a little bit of a kind of an exemplary review, I suppose. Okay. Corey, does that make sense?
Yeah, I think so. I do have a couple follow-up questions. So my understanding is we don't have as much information about this case as the ISC panel does. That's correct?
Well, one of the biggest things at the ISC panel, you can hear from that person directly.
Okay. So does staff have access to the same level of information as ISC?
Go ahead, Jane.
So there is one board member on there, but the panel actually includes staff and the board.
Yeah.
I guess my last question then is, just reading the ISC review and the summary here, it says that the mistake appears to be administrative and there's no evidence that the respondent was actually engaged in theft or any malicious intent. So could staff share then where the hesitancy is on your part from the ISC's recommendation?
That was the ISC panel's reasoning for staff looks at it and looks at a guilty plea and a 5-year probated probation for Medicaid fraud, which directly relates to the use of their license. They could not have done this, without the license. And so as it directly relates, staff didn't find those same mitigating circumstances, or wasn't necessarily swayed by it, I think.
Okay, thank you. That's helpful.
Yeah, the failure to report is big.
On the failure to report piece, are they still in that 5-year sentence?
They're currently on probation right now.
Currently in that? Okay.
Go ahead, Dr. Bradley.
I don't know to whom I should address this, but I remember looking at this about a week ago. And if I read it correctly, the executive director, and I'm assuming that's Mr. Spinks, okay, has the authority to dismiss a complaint if the panel recommends. And I don't want to put you on the spot, but I'm inferring here that you must have felt uncomfortable doing what you have authority to do.
Yes, ma'am. And it's okay to put me on the spot. That's what y'all pay me for. But yes, I did not, I was not comfortable dismissing the complaint based off of what I had seen and what I knew about it. But at the same time, I didn't want to just say, no, I'm not doing it. I wanted to make sure that, like Chair Hallbauer said it very good, this is like a fail safe that is kicked in. And Ms. Shannon and Mr. Rose, this is the only time this has ever happened that I can recall.
Yeah.
We've ever had this. It's a very
Since I
rare
read the
occurrence.
report.
But yeah, I did not want to I didn't want to come across as me saying no to a board member, i.e. one of my bosses. But I didn't feel comfortable doing it myself. So we discussed it and we felt like the best option was, okay, send this to the full board. If they are comfortable with it, then yes, I will sign off on it, or the board can vote and they can sign off on it.
Go ahead.
The other thing that troubled me in the ISC review, there is a statement that the respondent is unlikely to reoffend. Based on what? The person didn't come forth. I didn't know that till just now. It wasn't like, okay, I did something wrong and I'm going to admit it. They came forth because they had to.
So I wasn't at the ISC myself, so I don't personally have information to tell you what was discussed or said, but I shouldn't necessarily give you too much information about what was said. So that being said, that was just that information is provided because that was how the panel saw it. That was what their conclusion was. So, and I felt like it was important to kind of give some of their general reasoning of why they were.
But that's like saying that someone cheats on an exam one time, they're unlikely to do it a second time because they got caught. There's no evidence for that. And that troubles me.
Janie, did you have something to add?
Oh, I was just going to say, I think we have our penalty matrix for a reason, and this is on the penalty matrix. And so I would say we need to follow the matrix that we predetermined for this particular situation. I want clarification. I think I know this, just want to verify. The dismiss with a warning letter means there would be nothing attached to their license regarding this, but any of the penalties on the matrix means that this would be it would be listed under their license and they would have to report it on future applications and things, right?
In order to impose any penalty on the matrix, there would need to be an order entered. So either an agreed or a final order issued after,
Right.
fully litigating it. So yes, there'd have to be an order on it, and a dismissal or a dismissal with warning is the same as a dismissal. It's just dismissed with, hey, watch out next time, sort of a with guidance or.
Okay. We have two choices unless a third choice has kind of come to light after discussion. First choice is we can accept the panel's recommendation and dismiss the complaint. That's option A, accept what came out of the ISC. Option B is we can send the complaint back to staff for further investigation. And is it essentially sort of a redo, or is it or does it, tell us a little bit more about that second option. If we reject the ISC and it gets sent back, what that entails?
They would either try to investigate anything further, gather whatever information that was still needed. I don't know that more is needed, but that's still an option. And then it would attempt to be resolved. And then if it can't be resolved, then it would end up at a SOA hearing.
Yeah, this is a little unprecedented, so I wanted to make sure we have a good sense of the procedure for what happens. So.
We have over $100,000 that was paid back. There's now a criminal record. There's some things here. So, you know.
Say it again, Dr. Bradley.
I said, I want to see what the staff sees if we send it back to them, because we have a situation here that the respondent has paid back over $100,000, then that person that's just normal, they'd have a criminal record. And, you know, all of this, yes, that's punishment, but I'm not sure I'm feeling comfortable about what I'm hearing.
Right. With what are you, it sounds like what the question is what would staff go with this? What's the direction they would take with it? And so we would look at the penalty matrix. We would look at the past orders that we've done that might be similar to this. We would look at any sort of guidance like that and try to treat it in a similar fashion. So.
Okay. Yeah. So we have two options, and I will entertain it unless someone can point out a third option for me. But the two options are, number one, we accept the ISC panel's recommendation and this complaint is dismissed. Option number two is the complaint is sent back to staff for further investigation and further review. And will this come back to us?
It would only come back if this was litigated at SOA, and then you'd review a proposal for decision from SOA and make and look at a final order. If we're able to resolve it with an agreed order, then it could get resolved that way, and you wouldn't necessarily need to come back. It would come back as a report of the agreed order we entered into.
Okay.
I'll make a motion to deny the ISC review. In other words, do not accept it.
Second.
Okay, we do have a motion and a second. That is the second option that we're considering. Deny the ISC recommendation, and the complaint would be sent back to staff for further review, further investigation. Is there any discussion on the motion? Okay, hearing none. All those in favor of accepting the motion that we deny the ISC review, please raise your right hand. Okay, and by a 6-0 vote, that ISC panel review has been denied.
Mr. Chair, may I make a comment?
Please.
So I wanted to thank Mr. Spinks about getting back to our board, and I'll tell you that I, having served on San Antonio City Council, I really appreciate when staff, when you have a difference of opinion, you also get the board to also take a look and review. And I want to mention that and appreciate that and recognize that's a great respect to the board. Thank you.
Yeah, well said. You've caught on quickly that Daryl is invaluable. So, moving on, 11, rulemaking. Christina, can you go ahead and bring these up, please?
Yes, so the rules listed under Section A relate to proposed rules that the board proposed in January 31st of 2025. These are now proposed for adoption. You all did receive public comment on these rules, and at this point, you can decide to move forward with recommendation to BHEC for adoption, or you can decide to change it, go back to the drawing table, kind of go from there with these. And you can vote on them together or separate if you prefer.
Can you state the two rules, 681.72 and 681.140, what we're
Yes.
considering today?
So 681.72 is related to the required application materials. This is the rule that removes the expiration of the supervisor training course, the 5-year and the 2-year. So it would remove that expiration date of the course. And then the second rule is 681.140, requirements for continuing education, which clarifies the professional development to maintain competency in serving unique populations.
Right. And
May I request that we take them separately?
yes, that'd be fine. We want to go ahead and vote on 681.72. Okay.
Trying to get it up. Sorry. I move that we accept the proposed changes to 681.72, which removes the 5-year deadline on the supervisor training course.
I second.
Okay. We have a motion and a second regarding the adoption of the rule. Is there any discussion on the motion? Okay. Hearing none, please raise your right hand if you're in favor of the adoption. Okay. Adoption passes 6-0. And regarding 681.140, Patrick, please, in case anyone has not heard this explanation or heard the background for the impetus for this change, can you kind of tell us why we're discussing this today and how it's progressed from initially at the board level up to BHEC and then back to us today for possible adoption? Kind of give us a little background on it.
Sure. I'll first talk about how these rules first were began under the standardization committee, and they were all 4 boards. We tried to create a standardized continuing education rule for each of them and format them similarly. Not every single board is the identical ones, but they're all fairly similar. I would say they're pretty close. But each of the boards had a similar requirement. And I will say that each board has proposed similar changes, and the MFT board and the psychology board met about a week or 2 ago, and they both reviewed their comments and have proposed to adopt this up to the council. So this and the social work board meets next week as well to review similar changes. What this comes from, and initially this part of the rule came from a health. There was a committee report. It was the state health plan that had this sort of idea that the providers should. There's going to be a lot of people moving to Texas, and the providers should be knowledgeable about all the different populations in Texas, whether it's rural, whether it's military, whether it's whomever is coming to Texas from where they live, and so they should have some sort of knowledge and who they're providing services to and how to effectively provide those services to that particular person. And so what this change is designed to do is make that effective. And so as you can see in the comments, there are some that are for it, and then there are some that are obviously against it. I think some people have maybe misinterpreted what the ultimate goal behind it initially was for, but truly that's what it's for. It's to make sure that the person that's receiving the services is getting it from somebody that's able to deliver them to it. It's a lot of the continuing education requirements are knowledge-based and what sort of methodologies or techniques they could provide to a particular person, but this is focused on, hey, I may know how to provide that therapy really well, but am I able to provide it to that specific type of persons or groups of persons, and it's being educated in those sort of areas. So, anyways, that's the impetus, the crux behind what this change is intended to do.
Okay. Thank you. Board, any questions regarding new public members? Do you guys have any questions on this? Corey or Elisa? Okay. Then I do need a motion for adoption. Okay.
A motion to adopt the new requirements for continuing education as presented.
Okay. Do I have a second on that motion?
I'll second the motion, Mr. Chairman.
All right. Thank you, Mr. Rose. Okay, we do have a motion and a second for adoption of the CE requirement change. Is there any discussion on the motion? Okay. I am going to need to see hands raised on this one. So all in favor of the adoption of 681-140, please raise your right hand so we can see. 2, 3, 4. Okay. And all opposed? Same motion. And we have 2 abstain. Okay. Is that certify quorum under 4 passes, 2 abstain? Does that? Okay. We can. All right. I can take a second. Depends on how long.
Would you like to proceed with the other rules as well and come back to this?
Yeah, let's go ahead and proceed.
May I get into it?
9B, proposed amendments.
So these are new rules that are being proposed today. Let's see, again, these can be voted on separately or together, but for 681.91 LPC Associate License, there's a couple sections in here, so bear with me, but it's to clarify services cannot be provided without licensure. And it clarifies that the LPC associate the LPC associate may own and operate a private practice, but must still be under supervision. Requires the associate to submit appropriate forms when changing or adding a supervisor and notify current supervisors of the change. Requires the associate to inform supervisors of pending complaints. Clarifies that associates' experience hours will carry over, that if they do not complete the total hours within that 5-year of the LPC associate license, they would need to reapply, but they do not lose those experience hours they had so far. It requires the associate to inform each supervisor if a pending complaint is filed against the associate. It requires the associate to share a copy of remediation plans with all current and future supervisors. And if the board would like to go through each individual one, if there's some want to bring back or not, or more clarification on, for 68191, let me know.
And Mr. Chair, if I can maybe add some of the thoughts behind some of the issues these proposed changes are meant or designed to address.
Yes.
So some of the things staff has been seeing is in both licensing as well as the complaint side and some of the things that particularly 68191 is designed to address is one is associates may get complaints filed against them, and then the supervisor has no idea of the complaint. And so the idea behind some of the changes is to make sure that the supervisor is notified. Currently, under the current rules, both potentially have, liability for something that could have happened. That hasn't necessarily changed. That's currently already in the rules. The point being is that oftentimes the supervisor may have helpful information, and that it would be oftentimes, I think, probably good for the supervisor to know, hey, the associate got a complaint filed against them. What can we help to fix whatever issues were brought up in the complaint going forward? Because we realize that's kind of the point of the supervision process is associates are going to make mistakes, and that the point is they're there to learn from them. The supervisor may be there to help them with it, but it's also they can help provide information that can resolve the complaint. And so the point of that, obviously is to make it clear, hey, you need to let the supervisor know, because not all associates are, and some may think, oh, I don't know if I can, and so it's providing that clarity in the rule about that. The other part of it is we've seen in the licensing side is a supervisor might say, hey, or you need to do we need to do a remedial plan. There are issues. We need to try to fix these. And then the associate sometimes will say, things aren't working out, and they're just, I want to leave. And they haven't completed that remediation plan. And the point is a new supervisor may not know about those issues. And so we're trying to create the communication between the better communication between the two. And so those supervisors can communicate, they can share that information. And the next supervisor can look at the remediation plan and say, I don't like this, or I want to change it. Or they could say, yes, we need to implement this as well. But it's really more to create communication between them. That was the intent behind those changes.
Okay. Yes, please.
So when you mentioned about complaint, is that a formal complaint?
Mm-hmm. Correct.
Something that is actually filed against?
Filed with the agency. Mm-hmm.
Okay. And explain to me, or I'm not familiar with this industry, what are the liabilities? When you mention about liabilities, lawsuits or what type of liabilities are you talking about?
So generally speaking, we would say if the supervisor was well aware that the associate was doing, like, let's just take a very sort of benign example of under the statutory requirements, if a written request for records is received, they have to respond within 15 days. And if the associate is not responding within 15 days, that's technically a violation. If the supervisor is aware and is not trying to correct these things and just saying, yeah, ignore them, or, we don't ever give records, like, no, there's a statute that says they're entitled to the records. So if a supervisor is aware of them, they could be potentially liable for, poor supervision, as well as the violation of not providing them. Now, if the supervisor has no knowledge of it, we don't necessarily automatically say the supervisor is liable for everything. We will look at that supervisor relationship and say, were they doing their due diligence as a supervisor? Were they actually meeting with them and doing the 4 hours of required supervision every month? Were they discussing these issues? Were they trying to fix them going forward? And if they're doing those sorts of things, we're not necessarily sanctioning a supervisor for all their violations. The point is that they can be if they're not actively supervising them or doing things that would help correct these sorts of issues. So it's a fact by case by case, fact intensive analysis we'd have to do, but generally that's kind of how it's
So in
handled.
this case, the changes would help the supervisor to avoid some of those scenarios from happening.
Potentially.
And is this something that the associate needs to disclose at the beginning of the association with the supervisor?
So that's part of what's in the rule, is that when they begin the new supervision with a subsequent supervisor, they need to, provide a copy of the remediation plan, let them know like who the supervisor was. I believe that's in the rule. So it's supposed to try to help that sort of communication and that, between the two.
Thank you.
I'll just say one of the things that came across when I was reviewing this is that the phrase continuity of care. And so if we were medical doctors and someone had a health issue with one provider, you would want that other provider that they move to know what the issues were so that they can better serve that patient. And I like some of the changes because it's not damning, but it allows that next supervisor to say, let me assist you with these issues, as opposed to they have no knowledge that they were there at all. So there's that continuity of care if we're charged with taking care of the next generation of clinicians.
Okay. Go ahead, Jane.
Are you ready for a motion?
I don't think we have additional discussion, so sure.
I move that we accept the the changes to Rule 68191.
We can do 93 at the same time if you want, but it's your motion.
And 93.
Okay. So we do have a motion to accept the proposed amendments to 68191 and 68193. Do I have a second? Okay. Dr. Bradley seconds the motion. Okay. We do have a motion and a second to accept the proposed amendments. Any discussion on the motion?
Yes, Mr. Chair. Sorry. I heard from the public meeting something about additional documentation that will be somewhat burdensome and also more liability. Can perhaps someone expand on that? What were the concerns? Because I think that's what I heard during the public comments.
Sure. So in 68193, I believe there's already a provision that talks about the liability for the supervisor. It's added to 91, but it's not necessarily meant to make it double liability. I think it's just as an explanation in that part of the rule about the supervisory relationship. So it's not meant to change any of the liability, the way it's drafted. So it's not, in my opinion, it's not intended to make it, make a stronger sense of liability for the supervisor that already exists. I think it's just
clarification.
It was meant to add it to that part of the rule so that it's clear there is a liability, but there's, things that I forget exactly where it's added. I just know that it was added to that part on 91, and I think that's why possibly people are worried that it's somehow increasing it. I'm trying to find it real
Yeah, I
fast.
think the concern was adding the duration and then where they're practicing. But I think those are, I mean, you're noting if it's a 1 hour supervision or if it's like, if you're meeting every other week for 2 hours. So it's just meant for clarification. It's not meant, you still have to do the 4 hours. We don't care how you do it.
Right. I think that was the other part of it, correct, is that I think that came from licensing sometimes has difficulty when they're looking at records to understand, some of the records they don't necessarily, the rules don't specify that it has to say, did you meet for the duration of how long you met? It just says the dates of it. And so they were just asking for, duration and then I guess location. So.
The one thing I can add about the location is that we have been hearing a lot more about associates practicing from another state or working for companies where they may be seeing clients in other states and maybe not the correct way. Maybe they're not licensed in a state they should be, but associates are not sharing that information with their supervisors. So supervisors have no idea that they're seeing clients in other states or practicing while they're physically in another state, that kind of thing. So I think it's just more like helpful for supervisors and associates to be on that same level of where the associate is practicing and who they're, providing services to.
Okay. Any issue with that? Okay. Go ahead, Dr. Bradley.
This makes sense to me. This makes sense to me, but I did want to ask staff that these bullet points came up because of problems you all have witnessed.
I would say some of them, but some of them are also from the 4-year rule review as well. Yeah. And that's what the majority of the 4-year rule review is, suggestions from the public, from licensees, issues that they're having. And so when we look at it further as staff, We're trying to find better ways to make it easier for all parties and so.
Dr. Bradley, I can personally attest to what Christina just talked about on the location about associates practicing outside the state and their supervisor not knowing about it. I've had to deal with that personally myself as TD. So that is very problematic. And the supervisor didn't have a clue that was going on. So,
No, I think they're good changes, but we do have a motion and a second. And we did put 91 and 93 together, correct? Okay. All right, at this time, we will go ahead and vote. All in favor of adopting the proposed amendments to 68191 LPC Associate License and 68193 Supervisor Requirements, please signify by raising your right hand. Okay, and that is proposed for amendment, and that will now go to BHEC in a couple weeks. Okay, thank you.
and Mr. Chair, I looked up the rule on that vote earlier. You're fine. The vote's fine.
Okay.
Adoption recommendation.
We're
moving
satisfied.
forward. Yeah. You're good.
Okay, thank you for checking on that. On the motion, on the vote on the CE requirements, we have a quorum of 6, and the vote was 4 in favor and 2 abstained. And I wanted to verify that it was the abstains that were a bit of a wild card. I wanted to make sure that was still passed. So Daryl, check on it for me. Is that anything to add to that? Okay. 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 No, I appreciate you checking on it. Thank you. Okay. Moving ahead, we had some rule change petitions, and let's go ahead and get these introduced and begin discussion on them. 11C1 is a petition from Ms. Laurel Clement. Create steps for a counseling practice regarding the separation of a counselor from a practice and the records. Let's hear what the actual petition is asking for and what have been identified as the pertinent items for discussion. So Patrick, please proceed.
So for both of these particular petitions, I would recommend that the board deny them. But if a lot of the issues they bring up are things that are very interesting and relevant, so the problem is typically, and so they were worth further consideration and further potential rulemaking. I think the problem with both of these rule petitions is that typically a rule petition will have the language that they want either struck through or added, or the whole rule that they want adopted. So there's actually a fully formed rule for the board to look at and say, we like this, we don't like it. Both of these petitions are concepts or ideas or issues that are really just put to the board. And so because they don't have really something to propose at this time, that's why I would recommend denying them. Now, I would also recommend you then submit these issues or these petitions to the Rules Committee to then look at them further. And speaking with Christina, she had a great idea. Say, why don't we poll some of the other states to see what they're doing on some of these issues, so we could gather information to see how these issues are being addressed elsewhere, and how we could possibly bring, rules in the future for both of these. So that's my suggestion of how possibly to tackle both of these.
But we have the authority today to send either or both to the Rules Committee on our own, correct?
Correct. But typically, as a rule petition, you have to, if you approve it, it's to you're initiating rulemaking. Whereas if you deny it, you can still investigate it, look at it further, and fully understand the issues, and then do it at a later date. You don't necessarily have to do it. You have to initiate rulemaking if you approve these.
Okay.
And so that's why I'm saying I don't know how best to initiate that rulemaking. So that's why
I want to hear why your recommendation is that we deny them.
Yeah, that's truly why. It's just because we need more information, I think.
Okay.
Because so some of the issues, like Ms. Clements, it talks about wanting a ban on non-compete clauses. And so it's a very interesting issue. The FTC has a rule out that was mandating non-compete clauses, and there's a lot of litigation going on about that as well. So it's a very very interesting issue. I just don't think we know enough to say, yes, we can certainly do a rule on that. There need to be more research on, and a lot of the
what authority do we have to regulate a practice as opposed to an individual?
It's a very good question. Again, that's so.
That lawyer hat.
Right.
We issue licenses to individuals, not to practices. So
Yeah.
I mean, if we can pare down the issue a little bit.
And I think part of another thing she's talking about is the people joining and leaving a practice, and again, it goes back to how much does the agency want to dictate contractual terms that people enter into? How far is that going into our regulatory authority? And these are very good questions to think about before we fully propose or agree to. We are going to initiate rulemaking on these potential issues. So I think it's worth a further investigation. I just don't know that I don't have yes, this is a rule that we should do today, based on these, because there's not really a rule in these petitions.
I would think, from what I can tell, that there is kind of a consensus, or at least a majority opinion, that this is an issue, and and it can kind of, it's an issue sort of on both sides. But again, if I don't, the board should not step into areas that they do not have the authority to regulate. And if we're pretty clear on that, then the issue can be addressed in a different manner. And we can, something that we do have the authority to, can be brought to our attention for consideration. Right. It's kind of how I see it. Board, anything to add? I mean, we can discuss Ms. Clement's and Ms. Graham's, or we can discuss them separately. We can discuss them both together. I'm kind of flexible here. Personally, I'd like to address the ones brought up in the first one from Ms. Clement, if we could.
Separately.
Okay, let's do that. Right now, let's talk about Ms. Clement's petition regarding records, regarding non-competes. It's sort of a multifaceted proposal, and this is Corey and Elisa. This is where we ask questions of our professional members, because we don't run counseling practices, but we kind of like, what? For me, I'm an attorney. We can't have non-competes. That's brought up in this petition. So then I look at, well, how come you can have them in a different
engineering? There's totally different set of rules, and I was
Exactly.
very fascinated how in this industry, I heard in the public comment about this percentage of supervisor and associate, and I had a conversation, and then very different from my industry. So I'm learning. But I think from the
Exactly.
business standpoint, I can definitely provide a lot of comments.
That's perfect. You can say, in engineering, we do it this way, but apparently it's completely different over here. Explain to me why. Because I do that from the legal side. And the big one is, you can't put a non-compete on a associate lawyer that works for your firm. And well, the concern is they take all their clients and they leave. And that's the concern here with counseling, is they take all their clients and leave. And so why is it different? Should it be different? That's what we do. So Corey, make that pretty clear on your end. All right. So board discussion on this. It sounds like we're kind of limited in what we can actually do today, other than saying this issue warrants further consideration, but you can let us know what parts of it you believe warrant further consideration, and then following the discussion, consult with Patrick and Daryl, and they'll say, look, the best way to go about what you want to do is to do this, and we'll ask them that at the end. Okay. Good. All right. So just talking with the first one from Ms. Clement, what questions do we have regarding records, non-competes? What do you think? I've heard this discussed for years. frankly. And I don't know if things have kind of improved or gotten worse one way or the other. Right? But I'm also not a professional counselor. So I want to hear your thoughts on it.
I thought it was an interesting proposal, and I do think it needs to be vetted out a little bit and wordsmithed to where it is an actual rule, because it's not presented as a it is presented as an idea, not like the language that would go into the rule. And so definitely think, the rules committee could undertake that task to, and I think these are two separate things. Non-compete is one idea, and the disposition of records is another idea. I think those are two different.
Okay.
They would fall under two different rules, and so I just think these are some ideas that were presented to the board, and I do think it is warranted for us to look at them.
Okay, you're chair of the rules committee. You have, if you're willing to, your opinion on the merit of these considerations, it goes a long way. So if you believe that, hey, it's worth taking another look at, an additional look at, maybe kind of, here's the issue, but then something gets ferreted out, perhaps differently than what's being proposed. Okay.
Agreed, of course, with my counterpart. I would also just challenge understanding our scope and not overreaching into kind of what you mentioned earlier. We are not in the business of building businesses. And so we want to make sure that we stay within our scope of making sure that we facilitate an environment of counseling rules and regulations for our state, and not reaching into the business and saying what the business should and should not do.
Correct. Yeah. Patrick, something to add to that?
Did you want to look and see, did you want to hear from either of these rule petition authors?
Are they on?
They might be here. I think we could ask. I think one of them commented earlier during the
If Ms. Clement is available, we can give her 3 minutes.
I think Ms. Graham was
Yeah,
on earlier.
she spoke earlier.
Okay, you want me to let Ms.
Yeah, I'll let.
Ms. Clement?
Yes, thank you very much. And I do appreciate the fact that what Patrick said is absolutely correct. This is really more of a conversation than the presentation of a rule. As many of you know, I am an attorney and an LPC supervisor, and I represent therapists statewide. This is a collection of comments and ethical dilemmas that I have gotten for years. It really stems from two ethical issues. One is the fact that counselors are required to keep records for 7 years. And then also, counselors are not allowed to abandon their clients. And so probably the non-compete is probably the minor of the issues, but the other issues are really more central to the ethical issues. And I want to give you some examples of some of the issues that I hear. A counselor gives the practice owner 2 weeks notice, and then the counselor is immediately locked out of her EHR. She understands that the intent of the being locked out is so that she does not take client records with her. She's not allowed to have a termination session with her clients. The owner transitions the clients to a different therapist in her practice. The counselor feels betrayed by the owner, and the clients feel abandoned by the counselor. Another example, a counselor tells the practice owner that she is leaving and does not give 2 weeks notice. The owner finds out that the counselor has previously been downloading
all of her client files. She has already created a new website and informed her clients about her new address. The owner feels betrayed by the counselor, and the clients do not understand why everything has been done in secrecy. The counselor does so because she fears that she won't be allowed to take the clients with her. Another example, the practice owner says that the counselor can take her clients with her to the new practice owner, but that she must pay a bounty to the practice for the clients or pay a percentage of the counselor's future earnings that result from the clients. These are all actual examples. Let's say there is an agreement that the practice retains the client files. On occasion, after the counselor has departed the practice, the client requests the files from the counselor. However, the practice is actually the one that has the file. What happens? I can think of one instance where the owner said she would sell the file to the counselor for $100 so that the counselor could fulfill her ethical obligation of turning over the file to her client. Another instance was when I represented a counselor before the LPC board on a complaint. The board requested the client file from the counselor, as they understandably do and should do. The counselor did not have the file in her possession as the practice did. It was with her former employer. When she asked the practice owner for the client file, the owner would not give the counselor the file. And what ended up happening was the attorney for BHEC had to subpoena the client file from the practice owner in order to get the client file. Those are just some examples that I've heard over the years, and these are reasons why I think that we need to, as a profession, put our clients first and recognize the importance of our ethical rules.
Thank you, Counselor. Appreciate that. Janie, I'm gonna go back to you. You chair the Rules Committee, and if you believe that this warrants further consideration, then like I said, at the end, we're gonna ask Patrick and Daryl what's the best way to go about doing that.
Why don't I just do a motion that we deny this petition? And then we'll follow up.
And we'll follow it. Okay.
I move that we deny this petition.
Okay. Do I have a second on the denial?
A second.
Okay, we do have a motion for denial and a second. I would just throw a caveat on there is that we intend to review it further, but we're proceeding procedurally, and that's about it. We will kind of take a look at it. I know we're looking at a Rules Committee meeting coming up. So.
This correctly, that a vote to deny doesn't necessarily mean that that's the end of it.
Correct. We're denying this specific petition. Staff has warranted this as a petition for rulemaking, and just I'm speaking procedurally that this specific and all the various proposals associated with it, we will deny that specifically, but the Rules Committee is willing to kind of recognize, okay, we have a possible issue here, and let's get some ideas on it.
So there should be one procedurally to deny this, but I could make another motion to refer to Rules Committee.
I would permit that. Okay. So, board, all in favor of denying this specific rulemaking petition, please raise your hand. Okay. By a vote of 6-0, that motion is denied. And Dr. Bradley, do you want to make another motion?
Yes. Thank you.
I got you.
I would like to make a motion that we refer this issue to the Rules Committee, because in reading what Ms. Clement wrote, it seems to me that there's an issue here that we need to look at.
Okay.
So I recommend that we refer this to the Rules Committee for further investigation.
Okay. Do I have a second on that?
I'll second.
Thank you, Rules Committee Chair. We have a motion and a second. Any discussion? Okay, all in favor of referral of this issue that it presents, please raise your hand. Okay, that motion is now referred to the Rules Committee, and we do have one more rulemaking petition. Patrick, can you kind of give us a little background on what's being requested by Ms. Graham?
Yes, I mean,
Or Christina, whoever.
Oh. And again, as Ms. Graham spoke earlier in the comments, this is really, again, another discussion about the compensation agreements between associates and supervisors, and whether or not are certain things exploiting them or not. Again, it goes back to the same sort of discussion we had with Ms. Clements, is that yes, this warrants further discussion, I think, in by the investigation, an investigation by the Rules Committee, but we don't have really a rule or an idea of how best to address any of the issues raised in it. And so we would propose the same sort of action because, and again, going back to this, the government code requires we must initiate rulemaking proceedings, which we don't know how to do that because we don't know what sort of rule to do, or we can deny, but we could deny and still look into the issue. And that's essentially what I'm saying, because I don't have a good pathway forward at the moment for rulemaking at the moment.
Okay. Then I'm going to ask you the same question I did after the first one. What authority do we have to regulate business practices?
Yeah, and again, it's a good question to discuss, I think, and especially the Rules Committee can look at is how far would a rule go beyond our rulemaking authority? There are certain things that, yes, we should not be necessarily dictating all the terms of and all the contracts between associates and supervisors. But is there a level of could we say, if it's $1 million a day, supervision fee, would that exploit the associate? Probably so, but I don't know of many that could afford it. But are there some guardrails that we can put on it? I don't know the answer to that.
I think this has been a discussion for years.
Mhm.
This came up when we discussed whether associates could own their own business.
Mhm.
And now here it's popping up again, even though associates have been able to own their business for 4 years now. So longer? It's been longer? Oh. Okay.
But it has come up.
Yeah.
When I read this, I kept thinking, how is this handled like with physicians and Medicare? How does Medicare do this? I mean, 100, retaining 100% without compensation to associates doesn't seem right to me.
Well, I mean, that's why I'll go back to Christina's good idea. Is one of the ideas was to survey other states to see how are they addressing these issues. Do they have rules that address any of the issues raised about the fairness between the supervisor and supervisee, and then if so, does our statutes allow us to do similar sort of provisions? More investigation, I think, would be warranted for it. It's just
Personally, I have problems with using the term fair because that's not what we don't regulate fair. Now minimal standards I'm fine with, but fair depends on where you live. It depends on how good you are. It depends on the target, your client target group. We don't regulate, but we can't regulate fair. We can do some minimums. We can do that. That's just where I'm on it.
Same. I think one of the challenges for me is that we're speaking on an educated population, and the phrase that keeps coming to mind is the concept of free will. I can't imagine as an LPC associate that I would agree to be supervised by someone who's charging me 100, 200, 300, $1 million. I would simply say, thank you, no thank you. I understand that there is a demand, right? There are supervisors say we have 1,000 in the state and we may need more, but there's still the concept of free will. Some of the things that I've read are horrifying. If people are agreeing to go into something that is equivalent to servitude, I can't understand, and that may be a point of privilege for me, but I can't understand that concept of free will, and it goes both ways. So that's free will on the supervisor to charge an exorbitant price, understanding that you may not have people who want to come to you, and as a supervisee, not being able to afford that, not wanting to go to that supervisor. But I think if someone says, I'm going to pay you $5 a day to do 50 hours of work, at some point we have to rely on the knowledge that we've given to individuals to make an informed decision for themselves.
Right.
Miss Graham is on if you would like to give her 3 minutes.
She can have 3 minutes.
Miss Graham?
Yes. Thank you all for hearing me and for providing me the opportunity to speak. I think that I submitted this petition because even though everything in the petition may not affect me personally, we are a part of a systemic profession. And I hear the board members stating that this is that they cannot dictate or alter business practices. However, this is an ethical issue and concern, and it is deeper than just the wage or a supervision cost. We already feel stuck in the free will aspect when before we can even start our hours, we have to come prepared with a supervisor. We don't really, I hear you guys when you say that we can just go to another supervisor if we cannot afford or do not want to pay the fee. However, when the majority of the supervisors are either paying us a specific wage and or offering their services to us, then we really don't have any option or choice in that. Part of our supervision is going along with the licensure requirements. This is over the course of no less than 18 months per the state of Texas. Many associates take more than 18 months. And yes, I understand that it may seem like a wage in a business debate or practice on what someone is charging, but I do ask that you guys consider this petition and or further consideration with the deeper systemic issue that this presents. And I'm open to questions and or feedback if you guys need that. I have 50 seconds.
Thank you, Ms. Graham. Board, any specific questions for Ms. Graham, the one who brought this specific petition? Okay. Are there aspects to the petition that you believe warrant further consideration and would like to see assigned or brought up for consideration in one of our committee meetings?
I will respond yes. Does require further consideration. When I read what she wrote, I thought, well, I'm not aware of this happening, but because I'm not aware of it, then it must be happening or she wouldn't have written it. And I think we need to look at that. I'm not sure how much authority we have, but I think we need to look at the issues that she's brought up.
Okay. For me, it comes down to Christina has expressed willingness to reach out to her myriad of contacts across the nation on finding out how this is kind of addressed in other states and what they tried and it didn't work, what they tried and it did work, but it worked in a different way. She said that she would be willing to do that and basically give us some information on perhaps states that also had this brought to their attention, and they did make an effort to make a change. What they did and what the result of it was, and it could be the result was we tried this and it was a horrible disaster, and we just got rid of it, or it could be we tried this, it didn't work out the way we thought it would. You're willing to do that?
Absolutely.
Okay.
Mr. Chair, there's one other alternative I want to pitch out there. It has nothing to do with the board and the agency. So I need Ms. Graham and all your cohorts that are listening and are kind of aligned with your viewpoint on the issue. But back in the 83rd legislature, the regular session, I want y'all to go look up House Bill 808. It is a delegation bill that the Texas Psychological Association got passed and is now in the law. And basically what it is designed to do is allow your supervisors to bill at their rate for the services that you perform. That may provide some economic relief or incentive to address. It's a different way of approaching the problem, because I'm afraid, I'm just going to tell you, Ms. Graham, what you're suggesting here gives me a lot of heartburn as to whether or not we have authority to do it. And quite frankly, whether we would even want to wade into that political minefield of trying to regulate something like that. That's going to be frowned upon, I think, by elected officials. But the House Bill 808, if you can go that route and you've got the moxie to go over to the Capitol and find somebody to carry that bill, that's going to be a much more surefire way of getting the type of relief that you're looking for. But you're going to have to craft a solution where both sides win.
And Daryl, how does that overlay with the recent House Bill 1716 and Senate Bill 469, which failed in the current?
Are those the refresh my memory?
Medicaid reimbursement for associates.
So Medicaid deals with, you're talking about a multi-billion-dollar budget there that the state pays out of pocket. House Bill 808 does deal with third-party payers, but you're also talking about private insurers, so that's not coming out of the state's pocket. And it's also, I think it was probably, I was involved in it, but it's been so long ago now, it's hard for me to remember everything, but it's kind of pitched as a way to improve access to care, because it incentivizes supervisors to use their supervisees, send them out, deliver services, because they can bill at their hourly rate for something the supervisee did. So, that might be a way to kind of help. I'm just trying to think outside the box, and I'm spitballing from the dais up here. So just cut me a little slack if it's just not what you're looking for. But
what session was that?
The 83rd regular session. Don't look in the special called sessions.
Okay. Okay. All right. I've requested that Christina, I love giving work to Christina, of course, but I've requested that she kind of take a look at what some other states have done and the result, if they have it. It could be that this is an issue in every state, could be this is an issue in certain states. And I'm willing to find additional information on it. So I'm going to ask for that. Anything else associated with this specific issue? Okay. Before we put it on any of the committees, can we just kind of hear from you, and then we will decide to go where to go from there?
Sure. Right.
Okay.
We still have to deny it today, but
Yeah.
see what information.
Okay.
Right?
Yeah.
Yeah. So it would be a formal denial. Do you not want to formally, you just want to do more research before you do anything further on it?
That's my preference.
Okay.
But no,
That's fine.
we're a team here. I can entertain opposing ideas.
Are you ready for a motion?
Yeah, we need a motion to deny.
Okay. I move that we deny this petition.
Do you have a second? Thank you, Dr. Bradley. All right. All in favor of denying this petition, please signify by raising your hand. All right. 6-0 vote. The petition is denied. Christina, thank you for that.
Absolutely. And those that were
I
raising
need that by a Monday afternoon.
Those that were raising their hand, I apologize. It's not time for public comment. So just keep an eye on things that are going on with it. And if it comes up at another meeting where you can provide that public comment, just stay in the know that way. So I apologize for that, but we already did our public comment, so couldn't go back to it. Thank you though.
Okay. Item 12, recommendations for agenda items for the future. I know Dr. Bradley has something that she would like to bring up. Was it related to that? No. We're doing recommendations for future agenda items. Is that okay place for that? I'm going to give you a lot of latitude here. Go ahead.
Okay. 681.140, I was reading it more carefully and I just wanted to ask, when I voted for it, I thought it still allowed cultural diversity training and broadened it, but did I misinterpret? If I did, I want to vote against it.
Yes, it still allows. It's just asking you to seek CE training in an area that you are familiar with.
A distinct population, it says, but what I'm asking here is, could a person take a training in that says cultural diversity and still meet this?
Yeah.
So, okay. I just wanted to be sure, because if it doesn't allow
No, it did. They
for
can't.
that, I would change my vote because
It
I'm not
does.
voting against it.
Okay.
Okay.
All right. Are there any other items for new business? Frankly, we already identified some things that we want to look at in the future, but if there's anything else to add, this is your kind of open opportunity to do so. Okay. Hearing none. Our last item is an adjournment. I will entertain a motion that we dismiss.
So moved.
Thank you, Dr. Stubblefield, and a second from Dr. Amuna. At this time, I will just take a quick vote for adjournment. All in favor, please raise your right hand. Okay, that is unanimous. As always, Board, I thank you for your service to the great state of Texas, and we will see you at our next meeting. Thank you very much, and thanks everyone in our audience today.